All right, we'll call the afternoon session to order. We are on our 11 o'clock topic of judicial branch topics, administrative office of the courts. We concluded with a quick overview of the 10 funding points, and now we're ready to continue on. Ms. Butler?
Mr. Chairman, members of the committee, Elisa Butler, State Court Administrator for the Wyoming Judicial Branch. I don't know, Mr. Chairman, if I have anything else to add aside from maybe the budget impact. So for the positions that we are looking at, I think we're looking at about 2.5 million per biennium for all 10 of those positions. And Mr. Chair, 2.5. Mr. Chairman, I'd be happy to answer any questions.
Any questions for Ms. Butler? Senator Schuler.
Thank you, Mr. Chairman. Just a question I had when I was listening to your, I would love to see us get all these positions, but knowing that it's a budget session and, who knows how that's going to go, but if you had to prioritize these, would there be a priority order that you could kind of relate to us?
Ms. Butler.
Mr. Chairman, Senator Schuler, the list that you have in your materials, that would be our priority order. So that is listed in priority order as it sits today.
Mr. Co-Chairman.
So, Mr. Chairman, thank you. This, so you already have this in your budget document that you will share with the governor and on up the ranks. Is that correct? These are already going to be in your requested budget?
Ms. Butler.
Mr. Chairman, Mr. Co-Chairman, that is correct. We will have this built into our budget request to the Joint Appropriations Committee.
Thank you.
Senator Furphy.
Thank you, Mr. Chairman. Notice one of your requests is for a grant writer. Have you looked at the potential number of grants out there and dollar amount that might be utilized if you had a grant writer? Thank you.
Ms. Butler.
Mr. Chairman, Senator Furphy, we have looked at a number of different grant opportunities that are available. Most of them are through the Bureau of Justice Assistance, which is the ones that we're looking at right now. There are a lot of different states that have used those grants in a lot of different ways, but in terms of funding, it varies very obviously on what kind of request you're making and how much you can get. Just anecdotally, we've heard of states who get, $550,000 over a 3-year period for a training grant. I think some have received up to $800,000 or $900,000 for like a 3-year period. So there's a substantial amount of money available in those Bureau of Justice Assistance grants that we could hopefully take advantage of if we had somebody with the time and expertise to apply and then manage those grants over that time period.
Any further questions? Madam Chief, any closing comments?
Mr. Chairman, only one thing. We understand this is a budget issue, but it's also a judiciary issue and was an interim topic. So we appreciate your interest and would also appreciate your support going forward.
Understand. Any comments, any questions for the chief? All right. Committee, any motions relative to the administrative office thus far? Don't have a. Okay. Thank you much. Mr. Burlingame. Mr. Birmingham, welcome.
Chairman Washut, members of the Joint Judiciary Committee, my name is Ben Birmingham. I am Chief Legal Officer in the Administrative Office of the Wyoming Judicial Branch, and I'm here today to provide you with an update on the branch's behavioral health initiatives. And there are two initiatives. First, the transfer and enhancement of treatment courts, and then the diversion pilot projects. So I'll start with the treatment courts. As this committee knows, last year you sponsored legislation transferring treatment courts from the Wyoming Department of Health to the Wyoming Judicial Branch. And last month, the branch and the department submitted a joint report outlining this transition and providing a status update. And as you could see from that report, there are certainly some logistical details involved in moving a program from one branch of government to the other. We have worked closely with our partners at the Department of Health and believe we have resolved or close to resolving all of those logistical issues so that all positions, funds, obligations will be transferred on July 1st, 2024 without an interruption of service to our treatment courts or constituents. But in working through these logistical challenges, I think both the department and the judiciary have been focused on not losing sight of a bigger opportunity to improve treatment courts and to make them even more effective at helping Wyoming address our behavioral health challenges. So shortly after the legislation was enacted, transferring treatment courts, Chief Justice Fox and a number of our experienced treatment court judges and working with our colleagues at the Department of Health convened a treatment court advisory committee. This committee is comprised of over 20 state and local stakeholders, including the director of the Department of Corrections, the state public defender, county commissioners, county sheriff, prosecutors, treatment court magistrates, treatment court coordinators, sheriffs, law enforcement, provider representatives, a really broad group of stakeholders who are using this transition as an opportunity to take a close look at treatment courts to see how we might improve them. And in addition to convening this treatment court advisory committee, the judicial branch engaged an expert, a consultant, MPC Research, a group that has extensive experience evaluating treatment courts nationwide. And the committee worked with this consultant to review Wyoming's treatment courts, compare them to similar states. And this work has resulted in the report and recommendations that were submitted to this committee last month. I just want to give a quick highlight of those recommendations because those recommendations will serve as our framework, our guidelines for moving this transition forward and improving treatment courts. And the first main recommendation was to develop standards or rules to govern treatment courts. And these are standards that are based on nationally recognized evidence-based best practices, but that will be tailored to Wyoming and some of our unique circumstances and challenges. And we are working now with a subgroup of this large treatment court advisory committee to develop these standards with the plan to implement them by that transition date of July 1st, 2024. So we're looking at making these standards a bit more comprehensive, addressing things like data collection and management so that we can truly evaluate the effectiveness of treatment courts. We're looking at doing things like distinguishing and differentiating between the needs of adult treatment courts and juvenile treatment courts. So that's our goal to have in place by 2024, that transition date. By 2025, we hope to implement a certification process, the certification of treatment courts. And this process will serve as a formal mechanism for evaluating treatment court compliance with those standards, help us see where treatment courts might need technical assistance, help treatment courts ensure that they are following these evidence-based best practices. We hope to have that certification process implemented by 2025. And then in 2026, we are looking at creating a peer monitoring process, which is really a community learning group where treatment court members from certain treatment courts will form a team, visit other treatment courts to evaluate how these courts are working to administer their treatment courts and to comply with these best practices. And the thought is we can have a shared community where courts that have found solutions to different challenges can share those with other courts. And our courts will be a bit more coordinated just another measure to ensure that we are complying with these standards that we will develop. So it's our hope that working with this treatment court advisory committee, implementing these recommendations, we'll be able to not only successfully transfer treatment courts, but over the next 3 years, really improve treatment courts and make them even more effective at addressing Wyoming's behavioral health needs. So I'm certainly happy to stand for questions on treatment courts, or I can move forward to the diversion update.
Questions on treatment courts? Mr. Co-Chairman.
Mr. Chairman, thank you. Mr. Birmingham, thank you. This might be for actually both of the bullet points that you'll cover for us this afternoon, but along the way, I hope you'll take good notes. And it just feels like Wyoming's infrastructure may not be such that we can stand some of these things up right away. Have you already talked about that on the task force? What can you tell us about, and that plays right into where we might be able to plug in throughout the next interim and into the future? Hope that makes sense.
Mr. Birmingham.
Chairman Washut, Co-Chairman Landon, we fully recognize that there are larger issues at play here. I think we also recognize we have limited staffing, which is why we're trying to roll this out with standards in 2024, certification in 2025, and peer review process in 2026. The task force, or not task force, this advisory committee is taking also a look at statutes and statutory improvements. And we weren't quite ready to provide those to the committee this session, but we're hoping to do it in the interim to look at ways to statutorily support and improve treatment courts.
Just one quick question on it. This whole idea of certification, I'm just cautious about this because I've seen organizations that get all into certification standards, yada, 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 and it becomes kind of a bureaucratic tiger, right? A workload issue that is achievable when you have organizations that are motivated to try and do the very best they can for the clients they serve. You don't always have to have, regimented certification stuff. Have you evaluated that, and do you really see that there's a benefit in having a formal certification process?
Chairman Washut, I agree with the concern. We certainly see that, and I think that's even more prevalent in Wyoming, where we have such lightly staffed treatment courts. So what we're doing in developing these certifications is we're looking at other states. I think the gold standard is New Mexico. It has a very robust certification process, but we're understanding that what New Mexico does with its staffing, Wyoming may not be able to accomplish. So we're looking at creating a scaled back certification process. And we have treatment court coordinators from small and large counties on that working group just to provide a check, making sure we're not getting to the point where our certification process does more harm than good. And we're really hoping it can be a learning tool to help courts see where they may be falling short, and to help the branch identify where do those courts need technical assistance, where can we step in and support and provide training.
All right, thank you. Let's move to bullet point number 2.
All right. Thank you, Chairman Washut. So the 3-branch diversion pilot tests a hypothesis that has been proven elsewhere in other jurisdictions, and the hypothesis is this: diverting those with serious mental illness who commit low-level offenses away from the criminal justice system and into community-based treatment and services will stop or at least slow down the unproductive recycling of the mentally ill through our criminal justice system, and will ease the burdens on our law enforcement, jails, courts, and state hospital. Another way to put this is the state, our criminal justice systems expend significant resources incarcerating and evaluating the mentally ill, only to later reincarcerate and reevaluate. And the pilot program is seeking a better way, a more effective use of these resources. So recognizing this need and opportunity to try an alternative approach, Chief Justice Fox, Chief and Judge Phillips and Judge Castano in Campbell County convened a group of stakeholders and also, of course, working with Director Johansson and his staff. The stakeholders in Campbell County include law enforcement, the sheriff, police department, city attorney, city judge, public health, the county hospital, among others. And this group is working to find this alternative approach. So in our first meeting, the group quickly came to a consensus that the approach now is expensive and it's ineffective and it's not beneficial to these individuals, and it's certainly difficult on those who participate in the criminal justice system, our detention staff, prosecutors, public defenders. So we quickly reached a consensus that the current system is not working and we need to try something new. So based on this consensus and this shared desire to experiment, try something new, that group of stakeholders in Campbell County has identified a governing structure, developed some foundational documents, and sketched out a workflow for how this diversion pilot program might work. And what I'd like to do today, Chairman Washut, is walk the committee through this workflow. So I'll try to share this now so that you can better see it, but this was included in our materials. All right. So I need to start with the disclaimer that this is a work in progress. There's still a lot of details to be determined, but this is where we are right now. And you'll see, if I can get this to work. You'll see that this workflow lies under what's called the sequential intercept map, or the sequential intercept model, also referred to as SIM. And these are points in the criminal justice system where an individual with serious mental illness may come into contact with law enforcement. And the thought is that these different intercepts, we want to find a way to divert these folks away from the criminal justice system and into community-based treatment and services. Ideally, a diversion program will cover each intercept. Right now, the pilot program in Gillette and Campbell County is focused on intercept 2, which is initial detention, initial court hearing. And this workflow can be broken into 3 stages. We have an evaluation stage, an enrollment stage, and a services stage. And I'll start with the evaluation stage. So each person who is booked into the Campbell County Detention Center will be screened. It's called the Brief Jail Mental Health Screen. And this is a rough screening that can be performed by detention center staff that looks to flag those who may be suffering from a serious mental illness. If the screening does not flag a potential serious mental illness, then the person will remain on the traditional criminal justice track. If the screening does flag there may be an issue here, then the person will be evaluated by a clinician to determine whether the person suffers from a serious mental illness.
Just a quick question on that, Mr. Birmingham. That screening by detention staff, do you anticipate that being done by CIT trained detention deputies or by nursing staff, or a combination of both?
Representative Walsh, I'm not sure we've completely answered that question, but I know Campbell County does have a nursing staff that would be available to perform these screenings. But the screening is constructed in such a way that any lay person, even someone without a medical background, can perform that.
And secondly, is substance abuse itself, by itself, a serious mental illness? Does it meet the qualifications here? Or does it have to be mental illness plus substance abuse?
Representative Walsh, so right now, it has to be a serious mental illness, which does not include a substance use. The stakeholders are still discussing whether someone with a serious mental illness who has a co-occurring substance use disorder should participate. Those types of eligibility discussions are ongoing, but the current focus is on schizophrenia, schizoaffective disorder, bipolar disorder, major depression, and at our last stakeholder meeting, we started considering including those with post-traumatic stress disorder so we can reach some of our veteran population. So,
Representative Jennings.
Thank you, Mr. Chairman. So just a question there real quick, not being a lawyer. So are these screenings, are they voluntary? Do the people know that they're being screened, or is it, is it court ordered?
Representative Washut, Representative Jennings, these screenings are not court ordered. This would be part of the standard booking process. And I'm frankly not familiar enough with Campbell County's processes to know what the disclosures or disclaimers look like. So we'll have this brief jail mental health screen. If it flags a potential serious mental illness, the person will be evaluated by our service provider. And if that clinical evaluation confirms a serious mental illness, then the person will then be referred for a criminogenic risk assessment, which is looking for someone with a moderate, high, or very high risk of criminal behavior. If that risk assessment does not show a risk of criminal behavior that's moderate, high, or very high, then the person will remain on the criminal justice track. If the assessment does validate a very high, high, or moderate category of risk, then the diversion court team will be notified. And this diversion court team will consist of the judge, prosecutor, defense counsel representative, law enforcement representative, peer mentors, and case managers, similar to the treatment court model. This team will meet to evaluate the individual, confirm that the person meets the diversion program criteria, which is someone who has one of these qualifying serious mental illnesses and who has committed a low-level nonviolent offense. And so that diversion team will seek to make that confirmation before extending an invitation to participate in the program. But importantly, this is also the point in the flow where the prosecutor has an opportunity to object to someone participating. So the prosecutor may be familiar with the person's history and background and can make a determination as to whether the person presents a public health and safety risk and whether the person it'd be best for the community if the person remained on the criminal justice track. So if the team confirms the person meets the criteria, if the prosecutor consents to participation, then an invitation will be extended to the individual. An individual can participate, but the individual must waive that right to a speedy trial and must agree to participate in the diversion court. If the person agrees to participate in the program to waive that right to a speedy trial, then the prosecutor will agree to hold charges in abeyance pending completion of diversion court. So this takes us from the evaluation stage to that enrollment stage that we discussed to the services stage. So the diversion court, one of the team members will be a treatment provider, and this provider will create an individualized treatment plan. And in order to graduate from diversion court, the person must complete this plan. The diversion court will also seek to connect the person with those community-based resources. And if the person withdraws from the diversion court or fails to comply with those medication requirements or treatment requirements, then the person will be withdrawn from the program, and the prosecutor then would have an opportunity to continue those criminal charges on the traditional criminal justice track. But if the person does complete the individualized treatment plan, and the person will graduate, and the prosecutor will agree then to completely drop the charges. So that is an overview of where the diversion court stands, or the diversion program stands currently. Like I said, there's still considerable amounts of details to work through. We are hoping, though, to launch early first quarter 2024 with the understanding that this will in some ways be, we'll be learning by trial and error as we work through this. But again, we are seeking a better way, a more effective use, a more humane use of our criminal justice resources. So with that, Representative Washut, or Chairman Washut, I'd certainly be happy to stand for any questions.
Any questions? Well, I wish you the very best. I know the committee is thankful that you're going to collect good data. Data has been a downfall on many of our efforts in terms of setting policy, and it's very much appreciated that this diversion pilot is going to gather data that we can then fall back on and make good decisions with. So thank you very much for that. All right.
Certainly.
Thank you much. Nope, one more.
As we transition to the next topic, I just wanted to share with the committee, I've taken a few notes that we may want to consider for the two chairmen to forward on to folks like the committees and the management council. And in this particular area, I think it's important that we keep the Appropriations Committee and others informed of the fact that this diversion program is looming, and it's something that we support, I think, as a committee. And at least the initial outlay in terms of infrastructure and other things that we may need, I just want to make sure that we're in position to have the appropriations folks be on ready in the next couple of years. So we can talk about that a little bit later, but I've got some bullet points that I think are important for us to pass along. So, thank you.
All right, that brings us to the end of our 11 o'clock topic. And at the end of that topic, we always offer an opportunity for public comment. Public comment.
Time for lunch.
I think there are some people that wanted to chime in here. Thank you, Director.
By the way, Mr. Chairman, I'm looking back at Jill in the back there, and thank you very much for the tour of the Justice Center. Really appreciated that. Do we have somebody coming?
Yeah. Just on the topic of our tour, the committee had the opportunity to go through the Townsend Justice Center over the lunch period and see the rather sophisticated security systems that have been built into that building. And one of the points we had to acknowledge was that here in Natrona County, where our court building is separate from the rest of county government, you can build security features differently than you can when you have a shared space where your treasurer and your clerk and other county employees are operating in that facility. So it was quite enlightening. I hope the committee found it worthwhile for us to spend a little time getting a firsthand look. And most of us have never been down in the bowels of the courthouse and the lockup facility and all the camera monitoring and all the rest that goes into that. It's a pretty elaborate system that we have here in place. And as Judge Wilking said, it's kind of the gold standard in her estimation for courthouse security. So public comment.
Mr. Chairman, just to put a punctuation mark on the lunch hour, I have to confess, and maybe that disqualifies me for being the chairman of this committee, but I've never been in a courtroom. I literally have never been in a courtroom for any reason. I did go one time. I got a summons from the jury pool, and I went, and one of the judges who has since retired called me up front and he said, "What are you doing here?" And I said, "Well, I got summoned to be on the jury." And he said, it's not appropriate really for you to be on the jury. So you're a public servant, see you later. So that was it was really enlightening for me, Mr. Chairman. So. I have been, so it balances out.
Some of us might balance that off a little bit there.
Yeah, there you go.
Mr. City Manager, we're taking public comment now on judicial topics, and I understand you have something to share with the committee.
Thank you, Mr. Co-Chairman. Mr. Co-Chairman, members of the committee, thank you very much for your time today. We are struggling.
Would you please introduce yourself?
Yeah,
with your-
my apologies, you bet. Carter Napier, I'm the city manager here in Casper, and we appreciate your meeting here in our fair community. Thank you again, Mr. Chairman. We are struggling with some matters these days that may not be horribly unique to our moment in history that we find ourselves right now. However, it is feeling pretty intense with respect to the number of prosecutions that we're involved in and the number of public safety matters that we're engaged in as well, as it relates to what seems to be and feels like our expanding homeless community here in Casper. We heard a report just the other day from our municipal court judge who indicated that we are indeed 20% higher than where we were this time last year with regard to crimes committed by our homeless community and those interactions that we find ourselves navigating and dealing with right now. Some of the issues that I was hoping our partners in the social service world would help you see a little more clearly than I'll be equipped to do today, would verify that matter as well as indicate to you some of the strain that they're feeling from a social service perspective and the nonprofit world, if you will, in extending services to this part of our community. Some of the matters that we have learned about and discovered, particularly since we've taken the effort to pull together what we call a coalition that's focused on homeless issues here in our community, has brought to pass and certainly surfaced a couple of matters that we wanted to visit with you about today. One of the things that we're really struggling with is with regard to a number of communities, a number of agencies, government agencies as well, sponsoring the transportation of homeless folks who are committing crimes in their communities to our community here. And when they arrive in our community, they arrive without any arrangements whatsoever with service providers, without any networks that can provide them help. And in fact, it is very much a cold transfer, if you will, so that that particular community or that particular agency no longer has to deal with that problem and essentially foist that problem onto our citizens here in Casper and our service agencies and our public safety agencies and our court system and so on. The challenge that we have with that, of course, is number one, the services that we do have in our community are not geared to take on the entirety of the state's problems and folks who are in desperate need of services and help. And furthermore, if we did have availability within the services that we do have here in Casper, the arrangements are not being made in order to allow for those individuals to have access to those services or to be expected to receive those services or what have you. And so that lends to our suspicion that indeed these folks are just simply being transported here so that the public safety burden that they're experiencing becomes the public safety burden that we get to have as a result. In a very recent example, we had a situation where a community not far from here sent us approximately 15 people on a bus. All of them were hardened inebriates, and within 24 hours of their arrival here in our community, again with no warning, no indication of the services that they would need help with, our police department had to intervene with respect to criminal activity that they were undertaking, and those folks are here today, recurring in our public safety system over and over again. My question to this committee, and certainly to the state of Wyoming, would be, is this the kind of program or process or practice that you would like to see us do? Because indeed, we can load up a bus and we can send people all over the state. And as a matter of fact, we can not only load up that bus, but we can load it up with their newfound friends and send them as well. My suggestion would be that that is not the way to deal with this matter. Casper is not equipped to deal with the state's public safety problems. Yes, we do have services, and probably more than most throughout the state of Wyoming, but in no way were they designed around the idea of being able to accommodate or the task to take on individuals from a variety of places throughout the state. We're even finding that we're getting folks from out of the state as well, Billings, Portland. I've heard Denver, but we haven't actually gotten that indication in hard data, if you will. So then my question, again, goes back to, is this the process that the state would rather us do? At the expense of people's lives, at the expense of citizens who don't deserve this type of overburden, if you will, in their communities? My answer, humbly suggested to you, would be that is not the way that we should be doing this. And that, in fact, there should be a better way of navigating this problem, because it's not just a Casper problem. And it shouldn't be Casper's only to deal with, in my opinion. Mr. Chairman, so that fundamentally is the proposal that I have in front of you. I realize that the possibility of considering draft legislation and so on may not be readily available for us this season, this legislative season that we're about to go into. However, I would ask that the combined value of your thoughts and insights and input be brought to the table with regard to this conversation, to join with us in this dialogue, so that indeed, ultimately, if legislation is the right answer or an appropriate answer to consider, we all have that opportunity to have that exchange with each other. And that is my request. That's the comment that I have for you today, and I would stand for any questions that may be available.
Senator Case.
Thank you very much, Mr. Chairman and Mr. Napier, for being here. Good to see you again.
You too.
So there was a press report that said that these people, I believe they said it was 18 people, but and that they came from Fremont County. Is that true? And I have follow-up.
Mr. Chairman, Senator, that is my understanding.
Okay. Thank you very
Senator
much.
Case.
Thank you, Mr. Chairman. So I've been trying to figure out where they came from in Fremont County. I did talk to the mayor of the city of Riverton. I didn't talk to the mayor of the city of Lander. I've asked county commissioners, and it's kind of a amorphous kind of answers. None of them know of it. And, but if it's true, I find it to be just appalling. I really do. And I want to work with you on this, but I'd like to know more about these facts, and maybe other folks at this table know more about it. But I did read that, and it's very upsetting to me. So I'd like to get to the bottom of it, and I'm happy to talk online or offline. But if Fremont County is bringing people to dump on your social services in Casper, that's very offensive. And so is it true or is it not? And does anybody at the table know if it's true?
Mr. Riemann, can I get you to come to the table? Hate to call you up cold, but you know, when we have these types of interactions between communities, I think the county commissioners might be an important constituent group to engage in this conversation. Are you aware of anything like this? Have you heard this type of conversation previously?
Mr. Chairman, I'm completely cold. I don't know anything about, you know, in particular a county busing people to a particular community. That seems out of character for the conversations we've had within the association.
Okay. Mr. Chairman. Mr. Co-Chairman.
Appreciate Senator Case bringing up a couple of questions. I can't confirm, you know, on a specific date or time or anything like that, but I will say that I've had constituents come forward to me very, very concerned about the spike in the kind of activity that the city manager just outlined. It's not confined to just one community by any means. We're fortunate to have a few more facilities here in Casper than others do, but my constituents tell me that we can't handle this. I mean, we're to a point where I was talking with, we have a rescue shelter here in our community. Very fortunate to have it. Glad for the patrons of that establishment. But we had someone show up from a community in Wyoming. Come to find out, she had already been exited from the facility in Casper. The reason she ended up in the other community. And that community sent her back here, where the director of our facility had to inform that she had already been exited. So appreciate the city manager coming, because it's something that's come to both of us here in this community, and it's an issue. We've got an issue with, and that's why a few minutes ago I brought up the whole idea of infrastructure. You know, are we set up to? I'm all for really leaning into the blocking sled on this diversion program and drug treatment, but are we really set up as a state infrastructure-wise to be able to handle what I think we need to be handling? And so thank you, Mr. Chairman.
Thank you, Mr. Co-Chairman. So, Mr. City Manager, you mentioned that these were hardened inebriates, but are there other issues with these people or beyond having alcohol issues?
Mr. Chairman, indeed, we do have a variety of public safety response that we have to provide. Certainly, public intox is one of them. Generally speaking, however, we also deal with crimes of assault. We had the other day an individual who many of you know, traveling through our community, and at a stoplight, we had one of these folks try to get into their car while they were at the stoplight. And they fortunately had the opportunity to speed away, and then the individual went to the next car behind them to try to get into that car. I'm not exactly sure what that individual would have been charged with in that particular instance, but it's those kinds of things that we're facing. We're dealing with significant, loitering kinds of issues, harassment in all of its forms. Without a doubt, the camping and the trashing of property, both public and private. We have a gamut of things that we're struggling with on the heels of an increasing homeless population here in our community.
I think you can call a friend. Chief,
You want to pass that down to?
pass that mic down and just add a little bit to the discussion here, what your experience has been.
In addition to the street inebriate, we are having significant issues with those that are also chronically suffering from mental illness. The situation that we're facing right now is this kind of en masse arrival of those hardened street inebriates, and also the ones that are just chronically mentally ill. So each of those different parties come with their own important aspects of public safety responses. Those that are suffering from mental illness take even more resources from public safety responses. It takes multiple officers to correctly de-escalate those situations. And so we continue to manifest this in ways that are truly harming the city, but also the public safety ability that we have here. For example, almost on a daily basis now, about 25% of the people that are being booked into jail identify as homeless. And many of those are brand new to our community. They're just new. They're not in our system until recently, but they've just started showing up en masse. How that manifests itself is last year, for example, I had a budgeted amount for incarcerating prisoners. Because of this influx, this 25% increase, my budget for incarceration went over by approximately that same amount to the tune of $800,000. This current year to date, if I keep going the way I'm going, I'm going to, having increased our budget already, we're going to far exceed it by another $700,000 this year. And that's the toll that is being taken on our community.
So I have several concerns here, obviously, but I think about launching this new pilot program up in Gillette. And if communities feel free to just load up a bus full of people that are frequenting their system and say, well, there's a program over in Gillette, let's just send all these folks over to Gillette. You're going to overwhelm the pilot program in Campbell County and defeat the whole purpose of trying to see if we can come up with a better approach to dealing with these folks. This idea of shipping people from town to town is highly problematic. And boy, like I said, we don't know who's behind it. Senator Case.
Mr. Chairman, thank you very much. And Mr. Napier, you and I go back a lot of years, actually. So I appreciate if you would keep me apprised to the extent that you can about how this was accomplished, or if it was accomplished, and what was the extent of it, and where you think it came from in Fremont County. And I would do my best to work with you to, I think it needs to be exposed. I think, I have a lot of opinions about homeless people and the challenges that we all face, but this fundamentally fails the test of being good citizens to each other in Wyoming, and it's despicable to me. So I hope that you and I could count on you to keep me in the loop, and I will keep the confidence to the extent you need it. Thank you.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. City Manager, I'm just curious if you know how many homeless shelters we have in the state of Wyoming. I do not.
Mr. City Manager.
Mr. Chairman, Madam Representative, I do not know how many we have. I could not tell you that.
Well, I just want to extend our thank you. Sometimes just getting these things out into the light and encouraging conversation between the Chiefs and Sheriffs Association, the County Commissioners, Wyoming Association of Municipalities, legislators. Maybe there's a path forward. I very much appreciate the offer of Senator Case to engage and welcome his participation, and I hope you'll take him up on it.
Mr. Chairman.
Mr. Co-Chairman.
Mr. Chairman, I appreciate the city manager and the police chief coming by. I wonder, I'm just curious and would maybe like some help from our staff. And we could save this till the end of the day, but I might as well, while it's on my mind, bring up the idea of maybe a little bit of research to see if other states have come up with anything that we may want to consider or at least be aware of, along with what would be our options on something like this, in terms of where do our statutes stand? What remedy would a community have in the case that was described to us? I know we tackled the issue a couple of years ago about simply coming up with enough budget so that a community could get somebody back home to where they came from after they received any services, for example. We didn't get that piece of legislation through, but I'm just wondering if the staff could help us on that and come back in the third meeting with whatever you've been able to run across. Any thoughts you'd have, Brian, would be very appreciated. Katie, thanks.
Further public comment. Are you wanting to testify on this topic or something related, or to the judicial topic that we just finished? please come up to the table and turn the mic on until it turns green and state your name and who you represent and what you'd like us to hear.
Okay. Thank you very much. Can you hear me all right? Is that close enough? Okay. All right. Thank you very much, everyone, for giving me an opportunity to speak here today. Out of respect for your time, I'll try to keep my comments brief. My name is Deb Clark. I'm a property owner, a business owner, a DDA member, and a mom. As an advocate for business and property owners in Casper, it is my firm belief in the importance of addressing the issue of homelessness in our city that brings me here today. It is important to first acknowledge the immense challenges faced by individuals affected by homelessness, addiction, and mental health issues. As someone whose life has been touched by each of these challenges, I have a compassionate heart for these individuals, and yet it is precisely because of these experiences throughout my own life that I am compelled to speak up for our broader community and to stand up for the rights of our citizens to a clean, safe, and prosperous environment. My overriding concern lies in the persisting belief that the solution to these issues lies in adding more resources and services to take care of the people on the streets. These resources can include day centers, soup kitchens, shelters, and addiction counseling centers, to name just a few. Now, please understand, I'm not trying to claim to understand how to address the issues of homelessness directly. That is not my area of expertise. So I'm really just speaking for the business owners as opposed to an advocate for the homeless. However, the facts are that our homeless population is increasing precisely because of the resources that we already have. Adding more services can, and indeed will, add at least a proportionate number of additional homeless seeking those resources, and very likely even more. As proof of this, we can look at the lessons learned from other cities across the country who, driven by the best of intentions, have poured money into solving the problem by adding such resources and services, and now find themselves drowning in their aftermath. The problem in these areas is proving to not only persist, but worsen, causing business owners, employees, consumers, and residents to flee these impacted areas, further exacerbating the situation. We here in Casper, Wyoming, must not repeat the same measures while somehow expecting different results. This becomes all the more relevant as our local leaders approach the federal government, seeking potentially millions of dollars in new funding to address this issue. I ask you to consider, with every proposed measure, what the 1-year, 3-year, 5-year projections would be if they were implemented. Is it likely that this will decrease the number of homelessness entering our city or increase it? It is an indisputable fact that the appeal of expanded services will attract an ever-increasing number of individuals from other cities and states who are in search of such assistance, pushing our resources, our business owners, and our citizens in general to the brink. I ask that you keep at the forefront of mind the rights of Casper's citizens. I'm referring to those who aspire to start businesses or want to shop downtown or simply feel safe as they navigate our streets. And please consider deeply the very real concerns of business owners who feel backed into a corner, afraid of what they're seeing happen in their shops and in their community, yet also afraid to speak out for fear of backlash and being branded as heartless. If these issues are not addressed, I can foresee a day where business owners choose to either close their shops or move to another town where they feel their concerns are being heard and prioritized. To accomplish this, we must accept the fact that for every action taken, regardless of intention, there will be a corresponding effect on the surrounding community. Therefore, I ask you, our elected officials, to implement judicious and responsible measures that effectively deter homelessness while creating an environment that prioritizes the well-being of its citizens, nurtures economic prosperity, and promotes a sense of security for all. Thank you very much.
Thank you. Can I get you to state your name one more time for the record? I wasn't sure they caught it over the table.
Deb Clark.
Deb Clark. Thank you, Ms. We have a question for you, Ms. Clark. You have a question, please? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Ms. Clark, thank you for being here and for your testimony. I'd just like to get your opinion a little bit on potential legislation that can be passed in regards to the concept of squatting, that term that's kind of used where homeless come in and they take over a vacation home or a hotel or a business. Do you feel that Wyoming should move forward with something a little more beyond just our trespass statute?
Ms. Clark.
Well, first I would reiterate that I'm not an expert in these matters, nor am I as well versed with the legalities and the sensitivities around these issues that I perhaps could be as an advocate in this particular area. But I would voice support certainly for any measure that can be deemed to deter, as I mentioned in my comments, any increasing numbers of homeless. I believe that if, we certainly hear, and I've been on the homeless coalition that the city of Casper put together for almost 1.5 years now. And we've heard many times that word spreads. There's kind of a bit of a, like the telephone game that happens. And so if we were not to do something like that, and it were to, get around, I suppose, that, oh, Casper's a place that doesn't enforce these kinds of trespass laws. You find a place that's empty, you can move in, they can't do anything about it. I don't think you need to, to have too much experience in this to be able to guess what kind of an outcome that could potentially have. Where the opposite, I think, would also be true. That if we were to enforce things like trespass laws and do things to prevent people from moving into abandoned buildings, through whatever means we could potentially have, I think that word would equally spread, and it would create an environment that was less conducive to bringing in new people looking to take advantage of those types of situations.
All right, thank you. Appreciate you being here today.
Thank you, everyone.
All right, Mr. Gifford et al. All right, let's start with a quick review of the bill draft. Mr. Fuller.
Yep, so Mr. Chairman, 24 LSO 61 working draft 0.5. This is 6-01 in the online meeting materials. This is a bill draft the committee requested in April after a presentation from representatives of the State Bar. This bill draft is based on language that the bar provided, and it's based on a similar South Dakota law, would establish a temporary rural attorney recruitment program, a pilot program, and provide funding for that program. So starting on page 2, there is a finding to start off the bill that just notes that the legislature would find that the establishment of this program would constitute a valid public purpose of primary benefit to the citizens of the state of Wyoming. And I'll explain after I go through the bill a little bit more about that language. The Supreme Court, then page 2, line 14, may establish a rural attorney program to assist rural counties in recruiting attorneys to practice in those counties. Next is the eligibility requirements for a county in Wyoming to participate in the program. So the county, and this is on the top of page 3, first must have a population of not greater than 25,000. Second, the county must have an average of not greater than 1 1/2 licensed attorneys in the county for every 1,000 county residents. Third, the county must agree to provide the county share of the incentive payment that's required. And then fourth is determined to be eligible to participate by the Supreme Court. On page 3, line 14, before determining a county's eligibility, the Supreme Court must conduct an assessment to evaluate the county's need for an attorney and the county's ability to sustain and support an attorney in the program. And then the Supreme Court must maintain a list of counties that have been assessed and are eligible to participate in this program. And then the court can revise any county assessment or conduct a new one as the court deems necessary. Page 4, line 1, in selecting eligible counties to participate in the program, there's a list of considerations for this court. First, the county's demographics. Second, the age and number of attorneys in the county. And the staff comment there proposes an alternate language for paragraph 2. The committee may wish to consider the consideration of age as a factor in doing that, and whether that may raise any issues, by distinguishing between age. And so there's alternate language that would require consideration of the number of attorneys in the county and the number of attorneys projected to be practicing in the county over the next 5 years. Then page 4, line 24, any recommendations from the judges of that county, the county's economic development programs, the county's geographical location relative to other counties that may be participating in the program. On the top of page 5, an evaluation of any attorney who seeks to practice in the county as a program participant, including ties to that county, any prior participation of the county in the pilot program, and then any other factor that the court deems necessary. On page 5, line 12, a participating eligible county can enter into agreements with a municipality, a school district, or nonprofit entity with the county to assist the county in meeting the county's obligations, financial obligations for participating in the program. Page 5, line 18 is a reporting requirement, an annual report for each year that the program is in effect. This committee would receive a report on the activities of the program, the number of attorneys and counties participating, the amount of incentive payments that are made, and any recommendations for the program. On page 6, line 8, this gets into the attorney participation. So any attorney licensed to practice law in Wyoming, except as provided, I'll describe in a minute, can apply to participate in this rural attorney recruitment program. No attorney can participate if the attorney has previously participated in this program or has previously participated in any other similar state or federal scholarship program that obligated the attorney to provide legal services in an underserved area. Page 6, line 19, caps the number of attorneys who can participate in this pilot program at 5 at any one time. Then page 7, line 1, this is the incentive payment language. So subject to available funding and as consideration for providing legal services in that county, each attorney who's approved by the Supreme Court to participate in the program would be entitled to receive an incentive payment in 5 equal annual installments, and each annual installment shall be paid on or after July 1 of each year and equal to 90% of the University of Wyoming College of Law resident tuition and fee, or resident tuition for 30 credit hours and annual fees as of July 1, 2024. The staff comment is my kind of back of napkin math at calculating what that annual payment may be. Then page 7, line 26, subject to available funding, the Supreme Court would make that payment. The state bar in each participating county would have to provide its share of the incentive payment to the Supreme Court in a manner and by a date that the court specifies. And then that incentive payment that was described on page 7 is broken down as follows. So 50% would be from funds appropriated to the Supreme Court, 35% would be the responsibility of the participating county, and 15% would be provided by the state bar. Page 8, line 15, each attorney who participates in the program must enter into an agreement with the county, the state bar, and the Supreme Court, and the agreement would obligate the attorney to practice full-time in that county for not less than 5 years. And the agreement isn't effective until filed and approved by the Supreme Court. The staff comment on page 9 are just considerations for the committee. First, whether attorneys participating in the program must live in the county in which they're obligated to practice, and then whether language is needed to clarify what it means for an attorney in the program to practice law in the applicable county. So, for example, does that mean private practice and so forth? Page 9, line 15, an attorney who receives an incentive payment and breaches that agreement by not spending the requisite 5 years, for example, is required to repay all funds that are received pursuant to terms and conditions that the Supreme Court establishes. And failure to repay those funds is required is grounds for attorney discipline. Page 9, line 23 is rulemaking authority for the Supreme Court. And then the program ends on June 30, 2029. And the language on the top of page 10 would sunset the previous 2 sections that are created in this bill draft. Page 10, line 5 is the appropriation of $197,375 to the Supreme Court for purposes of the 50% share of the incentive payment that the court would be responsible for. With that, Mr. Chairman, Mr. Chairman, if I may, you received information about this as well. I would just note Article 16, Section 6AI, that prohibits the state or any county from relevant language making donations to or in aid of any person, individual, association, or corporation, except for necessary support of the poor. And so the language in the bill talking about consideration, talking about a valid public purpose, is meant to address that in part. The committee's considerations with this provision really is the state receiving adequate consideration in exchange for the payment? And second, is this for a public purpose? Those are kind of the 2 primary considerations that the committee may want to think about in evaluating this bill. And with that, Mr. Chairman, I'd stand for questions.
So let me start with the questions, Mr. Fuller. So we're setting up a program here in which the Wyoming Supreme Court is a participant and a player in approving, but we're also may face some state constitutional challenge as to whether or not the program itself is constitutional, or is it giving a donation of public funds to an individual in violation of the state constitution. Does that not create a muddled situation where now the Supreme Court is a party to a question that might come before the court?
Mr. Chairman, I'd be loath to comment on, on how that, how that may address how a challenge may be brought to the program. Whether that would be an action against the state itself or what have you. The South Dakota program is set up similarly with their court system being the kind of the operating entity. I think North Dakota's as well. So Mr. Chairman, it may well be an interesting position that the court could find itself in, but I wouldn't want to speculate on what that would look like.
Other questions for Mr. Fuller? Representative Jennings?
Thank you, Mr. Chairman. Mr. Fuller, my question comes from page 9, line 20 and 21, and I'm always very much in favor of subsidizing an industry such as lawyers, sometimes. So when we use the word shall, and this morning we had the problem that nothing was prosecuted, we tend to write another law that won't be prosecuted either, likely. So failure to repay funds shall be grounds for attorney discipline. But then we don't spell out what those disciplinary actions shall be. Could you elaborate a little more on that?
Yep. Mr. Chairman, Representative Jennings, I believe one of the speakers who will come after me is very, very well versed in disciplinary procedure for attorneys. But Mr. Chairman, I think to at least take a stab at the question, that process and the grounds for those discipline are spelled out in the rules of professional conduct that are applicable to lawyers in the state of Wyoming.
Representative Chestik.
Thank you, Mr. Chairman. Mr. Fuller, I'm on page 10, the appropriation on line 7. I assume that amount is calculated to be enough to pay for 5 lawyers for 5 years, the state share. Is that correct?
Yep. Mr. Chairman, Representative Chestic, that's correct. And that was a figure that the bar provided.
Follow up?
Yes. It'd be great if we adopted this and we got 5 lawyers to join the program in the first year, and then that would be perfect. But I'm not sure that's realistic. We may have lawyers joining in year 2, 3, or 4 of this program. Would the sunset of would the reversion on line 14 and 15 then need to be extended so we don't pull the rug out from under them? They join in year 3, they get 2 years, and then the appropriation expires. Wouldn't we have to amend the reversion date?
Mr. Fuller?
Mr. Chairman, Representative Chestic, certainly a policy question there. What I would say, though, is that if that is a direction the committee may wish to go, I think it would be not only that language, but it would be probably the actual programmatic language itself, which sunsets on June 30, 2029.
Senator Schuler? Nope, yeah. Say no further questions. We turn now to our panel of experts. Welcome back to Joint Judiciary. State your name for the record and tell us what you'd like us to hear about this bill draft.
Thank you, Mr. Chairman and members of the committee. My name is Kelly Neville. I've been an attorney practicing privately in Laramie for about 20 years. I'm past president and treasurer of the Wyoming State Bar, but also near and dear to my heart, I head the bar's Rural Practice Initiative, which is really an effort by the bar because the bar really sees its role as serving not only attorneys, that they are able to practice and practice ethically, but really to do that for the benefit of the public. And so the Rural Practice Initiative is a way to figure out how we can better serve members of the public that are out in more rural areas. We thank you for the opportunity to speak with you today and follow up on our conversation from the spring meeting on what we feel is a very important topic that does impact many Wyoming citizens. I have with me again Mark Gifford, who is Office of Bar Counsel and an invaluable member of the bar staff, and also Professor Alan Romero, who just hit 20 years with the Wyoming Law School, with a career committed to developing Wyoming lawyers, but also he serves as the director of the law school's Rural Law Center. So as with many professions, the legal profession, our members are aging, and as baby boomer attorneys are retiring, we have a situation where we don't have a line of younger attorneys going into those rural communities to fill those gaps, and that is leaving many citizens without assistance. And we're talking about very important matters. Not just, there's always criminal when people think of the courts, but we're talking about a lot of important things that might come up in a citizen's life, like the need to have guardianship over a minor grandchild or maybe an incompetent elderly parent, wills and powers of attorneys, a parent passing away and needing to administer their estate, business formation for economic development, help with nonprofit, zoning applications. And attorneys are vital components to all of these actions that really strengthen rural communities. The LSO draft bill that before you, it proposes a small pilot program to test the efficacy of a rural attorney recruitment program in Wyoming, modeled after the South Dakota one, which has been very successful since its inception in 2013. So they have over a decade of experience with their program. Hannah Hasgard is a University of South Dakota law professor who is working on publication of a scholarly work where she's looking at some numbers, looking at their program. And her findings include that up through March of 2023, 32 young attorneys participated in their program. They had a much larger pilot program of 16 attorneys, but they've had 32 participate. They agreed to go live, go live in a rural community, establish a practice, and they received a variety of supports offered by the program in addition to the stipend. And that support was helping find an office, hooking them up with a mentor attorney for questions, maybe connecting them with some sort of an institutional local client to give them some basic income to come in on a regular basis to help support their practice, and many other types of support. Of those 32 attorneys, 25 are still practicing in those communities. One became a middle school teacher in their community. Only 5 moved on to larger communities in South Dakota, and 1 moved out of state. So you can see 78% of the attorneys that participated went there, spent 5 years, created roots and a practice and a reputation and are continuing to serve those communities. Yes, sir.
I think we heard some of this at our meeting in April. I'd like to spend our precious time that we have really looking at this bill draft and the specifics of this. I think the committee agreed when we took the bill draft forward, we understand the nature of the issue and what we're trying to address with it. What we'd like to get at today is, does this bill draft get where we need to go?
Yes, thank you, Mr. Chairman. I'll get to those points. And I would say we really appreciate the draft bill. We believe that 5 is a sustainable way to start for us in Wyoming, that we don't need to necessarily have a 16-person pilot project like South Dakota did. We had a couple of potential revisions for the committee's consideration. The first one might be that this bill authorized the Bar Association to administer the program. All of the $197,000 go for attorney stipends. And so none of that provides any staff time for the Supreme Court to be the one to do that administrative work. And the bar is uniquely situated with the attorney relationships. We excel at hooking attorneys up with the various types of, practice supports and the small business aspect of running a law practice, that we could really help and support those attorneys. And we have the willingness. We've got some skin in the game. You can see we're doing 15% of the match in this program, and we really want to see this succeed and would like to offer that time and staff. And we are an arm of the Supreme Court. We're under their jurisdiction, and ask that could be delegated to the bar. And we do have consulted with the Chief Justice on that and have her support on that request. The second proposed revision that we might ask the committee to consider is the mandatory nature of the local contribution of 35%. One benefit we have from South Dakota in seeing how their program has run is that sometimes that's been a challenge for some of the local communities. And as you all know, some of our counties are very strapped financially, and that may be a stretch for them to fit into their budget, and that might prohibit them from having a willing attorney go in and serve their community. So one option might be to not make that precatory in order to get the entire stipend. We could if it were not precatory, then we could perhaps find other sources for that funding, or you might find even an attorney that might take less of a match in order to participate in the program. And then that community could still benefit from having some increased legal services in their community. And the last revision that we might ask the committee to consider is on page 3, lines 4 through 6. That's how you're calculating that ratio. 1,000 per 1,000 in population, you got to be at 1.5 or fewer licensed attorneys. And when we just take those numbers from the bar registration numbers, what we're looking at is just people who happen to have a law license in that community, an active law license, but it would include judges, prosecutors, retired, people who might be in a completely different profession, even though they have a law license, but a number of attorneys who are not available to serve the public in private practice representation. And so definitely want to gear towards that aspect. And we did provide some materials of some research that was done over the summer by Professor Romero and some of the law students, and they targeted the lowest ratio 8 counties in the state, like Niobrara, for example, attorneys who really have there's very little opportunity or options available for citizens in those communities, and took a look at who is really available to take a case if you need to evict a tenant, or you need help against a landlord, or you need a guardianship, or whatever it might be. Who could you go and hire? And so that information was provided. Understand that time is short today, so if the committee would like to hear, Professor Romero was here and he can discuss some of the comments with the committee, but that it was provided to you as a write-up from those students. And I think another important comment that Professor Romero could provide, if the committee would like to hear today, might be what kind of feedback he's getting from law students over the years about why they don't go into rural communities. And then now being able to talk with them this year and last year about, hey, there's a committee looking at this kind of a program. How does that change your thoughts on going into rural practice and going into some of the rural communities? And having those conversations and seeing the feedback from these students is really exciting. So those are the 3 items that we would specifically address particular to this bill, and do again appreciate the opportunity to address the committee on the topic again, and would be happy to take any questions.
Just a quick question. So if we dispense with the idea of a local match, where does, who carries that percentage that the locals would have covered before?
So I think it could be handled a couple of different ways. Perhaps the county could handle the local match. For example, Sweetwater County qualifies under the ratio as it's stated, and Sweetwater County might have those funds. However, Niobrara might not. And so maybe there is perhaps it's a private law firm in the state, or perhaps, somebody left some estate money to the Bar Foundation that's supporting this initiative, or we could otherwise raise the funds in order to kind of create that match. Or maybe you have a law student who would take a little bit less of a law, or not a law student, but an attorney who qualifies, who might take a smaller stipend to assist them with setting up their practice in a local community.
Questions? Representative Oakley.
Thank you, Chairman Washut. I just wanted to quickly, I guess, along with maybe some of these cleanups that we're going to discuss, talk about age. I know that Mr. Fuller had pointed that out. I didn't know if you had any thoughts on that. Page 4, line 6, not only for discriminatory purposes, which maybe he highlighted, but also, I mean, we're really looking at like years of experience. I don't know if you're seeing older law school. I mean, I know we've got somebody in their mid to late 40s as a first-year attorney in our office, for example. So anyway, just thoughts on that and maybe changing that to years of legal experience or something, years of being licensed.
Yeah, no objection at all from our
Ms.
perspective
Knebel,
on that.
to the chair. Thank
I
you.
apologize, Chairman Washut, members of the committee, Representative Oakley. No objection at all on that particular comment to, rather than considering age is one of the factors, looking at how the representation in the community is going to change over the next 5 years, which would be broader than age.
Mhm.
Representative Shestak.
Thank you, Mr. Chairman. I have several questions or comments. First of all, I would like to hear Professor Romero's discussion about what he's learned from his students about how this might affect their career choices.
Professor.
Mr. Chairman, Representative Chestek, and members of the committee. Yeah, I'm glad to be here and be able to share that with you. Last year, actually, this is my third year of surveying the first-year class, the incoming students at the College of Law, on this subject, and the results have been consistent. And I think it demonstrates the unique benefits that this kind of a program can provide, that even though it's part of a bigger effort, and the State Bar and the College of Law are committed to all kinds of activities to try to attract and prepare and support and retain rural lawyers. This provides a unique benefit, and it's evident in the students' reactions. So one of the questions I have asked them, the entire first-year class over the last few years, is their interest in serving in a rural community. And this year, for example, 46% of the students said they would most likely like to practice in a rural area. So there's substantial interest in practicing in such areas, although some of them might be thinking of other states than Wyoming, but most would be thinking of Wyoming. But when asked if they would seriously consider practicing in a rural Wyoming community if they received this financial support, 65% said yes. So it's an extra 50% of the incoming class who just knowing that possibility increases their seriousness about this opportunity. And I think that addresses one major obstacle that I have perceived in my experience with law students, which is, and young lawyers, which is the greatest obstacle to practicing law in a rural place is the uncertainty of income. I've done 3 surveys now, and every time that's by far the greatest obstacle that's cited, more than inadequacy of income. But it's that fear of starting a practice. It's probably gonna have to be a solo practice or joining a small rural practice, and you just don't know whether you can make it work, at the start. And so this kind of a incentive that is not just a bonus to attract, which I think is part of the effect too, because it signals that this is important, that they're valued. It gives them a feeling that there is a path to a rural practice, which is often an obstacle, but I think above all, it mitigates that fear that I'm going to get there and I'm not going to be able to pay my loans or eat. And the South Dakota experience certainly affirms that effect. All of the participants, well, almost all, Hannah Hexgard reported that this economic assistance was essential to their economic survival during the first 5 years of their practice.
Follow-up?
Yes, thank you, Mr. Chairman. Follow-up maybe for Ms. DeVille. I like the suggestion about having the state bar administer the program. That kind of starts to address, doesn't completely address, but starts to address the concern that Chairman Washit had about the Supreme Court having to rule on a program that it runs, which is kind of awkward, and it's a little less awkward if the state bar does it. But I want to focus on the comments from LSO about the potential constitutional issue about making direct grants to individuals without having a sufficient public purpose or sufficient consideration. I do think there is a concern there, but I think one of the ways that we can address that is trying to put some limitations, and I want your advice or your thoughts on how we can do this. Have some requirement that the attorneys participating have a public practice. They're not going to be located there to be a prosecutor. They're not going to locate there to be a law clerk. They're not going to locate there to start an internet-only trademarks or litigation practice or whatever. They're going to actually be doing the kinds of work that serve the needy population of the state. That helps us address the constitutional issue, but it also makes more sense for us spending money. Do you have any thoughts on how we can tailor this so that there's a requirement that the participants actually engage in the kind of practice that benefits the local community?
Yes.
Ms. Newbill.
Chairman Washit, Representative Chestek, thank you for that question. I think if you could tailor the bill additionally, but regardless of whether the bill language is refined more on that particular topic, the Supreme Court rules, and then the actual contract with the attorney would absolutely require them to be in private practice. That's our goal and our purpose is to be representing citizens in their private legal matters. And that they would need to do that for citizens of that county for a minimum number of hours, for example, 20 hours per week. So you could have, maybe to supplement your practice, you need to have some practice in some other counties and communities, but that you would still mainly be focusing your practice on that county that's supporting you.
Follow-up?
Final follow-up, just a comment, not a question. I do think I understand you could put those kinds of things in the rules and regulations. I would prefer to see them in the statute, mostly to address the constitutionality issue. That's a concern to me, and I think putting that in the statute would actually be a benefit to making sure that the statute survives.
Representative Harrelson.
Thank you, Mr. Chairman. So a couple questions. Currently, under Wyoming Bar, an attorney can practice in any community or any county or any city or any town in the state as long as they're under the Wyoming Bar, correct?
Correct. As long as they are licensed to practice.
Perfect. Okay, follow up. Okay, so with that, I guess the next question I have, and this is just where I guess I'm kind of getting stuck. I mean, we got a massive lack of mechanics in our community. So should we do an incentive for mechanics? And what, I mean, it's a month to get a haircut. Should we have that? I don't know. So I think the question that we have to start asking is, where do we stop? I mean, are we going to incentivize every single, I mean, at that point, there's kind of, I don't know. I'm just asking the question, where do we stop? And then if you mind, I'm going to tack one more on that. Is there anything keeping the bar right now from creating this program themselves and facilitating it for young rural attorneys to try replant back in this state? I mean, using the funds that you bring in from attorneys to help place attorneys where we need them?
Ms. Neville.
Chairman Washit, Representative Harrelson, thank you. To your first point, well, I guess I'll address the second point first. The bar has had this topic on its strategic plan now for the 6th year. We have put a large number of resources, and we need an entire toolbox to attack this issue, and this is just going to be one of the tools. And we have put significant funding of our own into a variety of things, and we'll continue to do that in order to try to address the problem. The type of stipend we're talking about, though, the bar just doesn't have that level of funding to sustain that, and we want to run a pilot and see how it goes and see if it's worth continuing. To your first point, why legal services versus a haircut, or a mechanic, and I think, you have types of things in life that take a variety of priorities. Medical care is so critical to every individual. And I would say that the third branch of government, the judicial system, people's protection of their property and their rights and the ability to care for their family, and the types of things that the legal system provides and that attorneys help people access, that those are critical level items similar to medical services. And I think I would prioritize them. The other things are absolutely important, but not being able to have your grandchild in a safe, secure environment because you can't hire an attorney to help get guardianship, that's a pretty critical matter that we need to pay attention to for our citizens, in my opinion. Thank you.
Representative Jennings.
Thank you, Mr. Chairman. I'm just going to dovetail on that. I mean, actually, I was thinking plumbers would be a little more important, but who knows? I mean, I've got a banker on one side and hotel on the others. Maybe we could, I look forward to those bills if this passes. But my question would be more dovetailed, and I believe Professor
Romero.
Okay. When I think about the university, I'm kind of curious why they have a vested interest. You're training our lawyers, and it seems like the more of them that you can get to stay in state, and seems like maybe you guys have a fairly good endowment. This might just be some coffee change or something. And so I'm kind of curious, did the university, did the bar talk with the university? Did the university, I mean, was there a reason that instead of coming to the state for this money, I mean, I'm a big proponent of getting government involved in every occupation that I can see them involved in. But this one, I'm just curious of where that went. What did that discussion look like? Or did it not happen? Or should it not happen?
Mr.
Whichever.
Chairman and Representative Jennings, we certainly have talked about it, thought about it. I think the College of Law does have something of a different role in that we don't have an ongoing role in managing the practicing lawyers, right? We prepare lawyers for the practice, and our funds reflect that. If there were such abundant funds, I certainly would be seeking them for this cause. I do think there are ways that the College of Law can contribute, and that's and maybe even some financial ways, but certainly not to this extent. It would have to come from somewhere else in order, it could come through the College of Law, but it wouldn't originate with the College of Law anyway. And so I think this particular kind of program at this scale, even though it's relatively modest relative to the income that, a new rural attorney is hoping for, I think the state contribution is essential. And I think that's reflected in how other states have responded to it, even though their law schools too have been very involved in the efforts.
Representative Craigo.
Thank you, Mr. Chairman. And so this could be a question for any of you, but as the bill draft's written, the young lawyer, the person we're recruiting, does not have to be from the University of Wyoming. They could be from any college. I mean, they could have been grown up in Wyoming, went to college, wherever, Stanford maybe, and then decided to come back to Wyoming. Is that right?
I think that's an affirmative nod over there. Any further questions? I'll close with this question. Earlier, I visited with you a little bit about might there be a role for some of the larger law firms to help defray some of these costs of starting up a brand new law practice? Not necessarily the lawyer would still live in small town Wyoming, but would be a member of the firm Big Town, Wyoming. And the Big Town would handle billing and some of the subscriptions and some of those support services, if you will, to defray the cost of starting a new practice. I think there's at least one firm that does something like that around Wyoming. Is that a viable idea here to help drive down the sticker shock to the taxpayer?
Chairman Washit, members of the committee, thank you for having us. There are firms that are reaching out that are expanding into satellite offices. So the market is driving them that way. They know there's a demand for lawyers in those communities. I'm thinking specifically of a Casper law firm that recently opened a Rock Springs office, for instance, because there just aren't lawyers to take things on. At the Wyoming State Bar, we run a lawyer referral service. We receive between 40 and 50 calls a day from people that are trying to find a lawyer. And a lot of those callers are from rural communities. And for a lot of them, we just don't have anybody to match them with. One thing that the bar is just about to launch is a formal mentoring program that's going to be ideal for young lawyers just starting out on their own, where we can match them. It actually follows like a Match.com dating app where we screen the people looking for a mentor and the mentors, and we try to put them together where there's a match. I think that's going to be very exciting because a lot of young lawyers wouldn't know how to hang out a shingle and open a practice in Sundance, Wyoming. But with the help of our mentoring program, which the bar's paying significant money to fund, that platform will be there. And while I've got the mic, I just wanted to mention one thing. There was a question about the discipline for lawyers, lawyers that don't pay back being subject to discipline. I think there's a better and more expedient way to skin that cat. Discipline is very procedure intensive. It takes months, if not years, to work through the system. But there are other things that we could do. I would suggest that a lawyer that doesn't fulfill their obligation under the statute to pay that money back is subject to having their license suspended, not on a disciplinary basis, but because we suspend the licenses of lawyers who don't pay their license fees. We suspend the licenses of lawyers who don't comply with the continuing legal education requirements. Those aren't disciplinary suspensions, but they lose their license all the same. There are statutes on the book that say a lawyer that doesn't pay their child support is subject to losing their law license. And thankfully, I haven't seen that statute used because I think the fact that it's there is a mighty incentive for lawyers to stay current on their child support obligations. So those are examples of other ways we can get at it without saying it's going to be attorney discipline. And I think it's more expedient and a lot cleaner.
Thank you. That was helpful. Anything further? Senator Case.
Thank you, Mr. Chairman. I'm inspired by my colleague. If the problem is with lawyers being new and not knowing how to run an office and have a practice, why don't you guys teach that?
Anyone? Professor?
Mr. Chairman, Senator Case, absolutely, completely agree. That's one of the many efforts that we are undertaking to try to better prepare and support young lawyers practicing in rural areas, both at the law school and beyond. We've the last few years, this working group that we've been working on has held conferences that are focused upon that kind of content. And the bar has lots of other practice management training to try to help them. And we are working on it's really personnel issue right now of also adding a course at the law school preceding their graduation that can also help to train them for managing a practice. Although I think that law school's experience generally with practice management courses is that they are inevitably general, and you need somebody there when you're doing it to deal with the particular things that you're working on. So I don't think it would take the place of those kinds of mentorships and assistance following graduation, but it certainly could help.
Representative Craigo.
Thank you, Mr. Chairman, and this might just be in response to the good senator's comment. And this isn't a question necessarily for the panel up here unless they want to respond, but I think it's the issue's a little bit more complex than we're not teaching them, or that they don't know how to hang out a shingle. I mean, some of these small town Wyoming towns, the issues that walk in the door, I'll speak from my personal experience, a lot of the issues that walk in the door where people need legal representation aren't well-paying jobs. The folks can't afford to pay you much to do a divorce or to go work on a custody battle, things like that. I mean, these are the areas where we're really short on representation. The big PI cases, personal injury cases, car wrecks, et cetera, they'll find a lawyer. It's the little stuff where you can't afford, for example, if you live in Niobrara County, you can't afford to go to Casper to get your lawyer, because by the time you pay them to drive to Niobrara County to handle your case, you're out a lot of money. And so the problem is getting the lawyers into our small towns. And how do we do that? I don't know the answer. I mean, I think this is a good idea, a good first step, but it's much more complex than we're not teaching them. We can't get them there. I mean, we just talked about this at the bar conference, the state bar convention last week. My days are like running together, but there are 14 licensed lawyers in my county. 4 of them practice law. And I'm one of those, and I'm part-time. And so it's really there are 3 lawyers in Buffalo that are taking cases, and I talked to them all, they all get calls every day to do those types of cases, and none of us have the time or the capacity to even take those cases. And so these people who, some of them maybe can't, we all try to do our fair share of free work for the public, and even with us taking some of those cases, we don't have enough lawyers to help out and fill the workload. And so then what happens is these folks are going to the court system without lawyers, and they're going pro se, which then gums up the system even more. And so a case that should get handled rather quickly in our court system is eating up our judges' time by the bucketful. I mean, a case that lawyers would probably be able to work out behind the scenes is now going to go to a 3-day bench trial. And so it's not just the front end of this of getting more lawyers, it's also us protecting the back end, which is our court system, and the effects it has on our clerks and our judges and the lawyers who have to then go practice against these pro se folks. Oftentimes it's our prosecutors or whoever not necessarily them on some of that stuff, but I think it's a bigger problem. I don't know the answer, but I think we got to do something to get some folks into these smaller communities to help with the problem.
Senator Cooper, we're coming up on 3:45 in the afternoon. So.
Thank you, Mr. Chairman. Just to add to what Representative Craig has said, page 3, line 5, and page 4, line 6, would one of you be able to give us a really good definition of what you think a licensed attorney is? Because just what the representative said, in my district, you'd be hard pressed in the whole district to find 5 practicing attorneys, let alone that would be willing to accept a case. So the definition of a licensed attorney in this thing is invalid. That's not who we're trying to help here. So would any of you have some better language available for that?
Licensed attorneys, any ideas?
Yes, Chairman Wash, Senator Cooper. Yeah, I did take a stab at some language that I emailed over to the LSO just for consideration, but it kind of said, instead of just licensed attorney, qualified licensed attorney, and maybe make that a defined term in the statute where you might say something like it's an attorney licensed in Wyoming who provides legal services to private citizens on a fee basis or pro bono, an average of 20 or more hours per week, and excludes, and then you could list things like excludes judges, prosecutors, law clerks, and some of those types of positions that are not able to provide private representation.
Mr. Chairman, may I add a comment?
Please.
And Senator Cooper. Just in connection with the research we did since the April meeting, I guess, pattern is dramatically evident. And I think, you know, the meeting materials include a brief summary of our findings, but if you look at that table, you'll see that we looked at 8 counties, all of which are under 1/2 a licensed attorney, actively licensed attorney for every 1,000 population. But all of them, when you exclude those kinds of attorneys who are not actually available to private clients, are well under 1 per 1,000 in population, which is the working legal desert definition nationally. So this is a pretty liberal qualification standard. It doesn't determine who actually would receive a position funded. It could do the job because everybody who is under 1/2 per 1,000 is certainly going to be well under the threshold for a significant need. But I do think if not in the eligibility requirement, maybe in the selection criteria, having some consideration of, well, how many attorneys are actually available, just like we include consideration of how many will continue to be available for the next 5 years, or what kind of retirements might be anticipated as well.
All right, thank you. 345, Representative Oakley.
Thank you, Chairman. Do you think it would help to, as far as criteria, to add an actively practicing something? I mean, then that gives the flexibility, just to add that into instead of the 1.5 licensed and actively practicing attorney.
Ms. Neville.
Chairman Washit, Representative Oakley, I think if you actively practice in private practice, yes, because I mean,
all that, yep, okay.
Yes, that might also be able to encompass more communities that really need help and make them eligible for the program.
Thank you. Committee, in the interest of time, might I suggest that we just carry this bill draft over to our November meeting for further consideration at that time?
Thank you, Mr. Chairman. And same as we've done before, I mean, I think we have a lot of ideas of the kind of cleanup that we need to do, submit those.
Yes, anyone with suggestions for amendments, submit those to the LSO before within the next couple of weeks so that they can work on them before the November meeting. And then without objection, we'll just continue this discussion in our November meeting. Thank you all for being here. Appreciate it.
Thank you.
Department of Corrections. Mr. Fuller, we have a bill draft 24 LSO 0048. That's yours or Katie's?
Chairman Washit, it's fine.
All right.
And if
please,
it's all right with.
Please walk us through the bill.
Chairman Washit, if it's all right, I'll walk through 48 and 49 together because they're intended to be alternatives. Katie Adams, LSO. This first bill is 24 LSO 48, Public Records DOC Investigations, Working Draft .5. For reference, Wyoming Statute Section 164203B1 contains the discretionary records of investigations exception to the Wyoming Public Records Act. This first bill draft just adds the words, the Department of Corrections Investigation Services Unit, to the list of persons and entities that are specified under that exception. And then as an alternative, there's 24 LSO 49, Public Records Department of Corrections Safety, Working Draft 0.5. And this bill draft creates a separate discretionary exception related to the Department of Corrections Investigation Services Unit. The language is modeled after the Records of Investigations exception, but the exception is narrowed to situations where inspection would endanger the life, health, safety, or welfare of any person. And with that, I would stand for any questions.
Committee questions for Katie? Okay. Welcome. We don't see you at Joint Judiciary, but nice to have you with us while your boss is out enjoying a little vacation time. So briefly, can you tell us, do you have a preference on one or the other of these two bill drafts, or any concerns about either?
Mr. Chairman, thank you for having us today. My name is Heather Babbitt. I'm the Deputy Director of the Department of Corrections, and as you said, Director Shannon is unable to be with us today and sends his regrets. With me here today is Major Tim Rysel. Major Rysel oversees the Investigative Services Unit and is available to help answer questions. When we looked at these bill drafts, I'm assuming, Mr. Chairman, you want us to dispense with any? Yes, sir. All right. We did have some question on the bill draft 0049. Which, if you see on the, second page, line 10 in the amended language where it says compiled for law enforcement purposes, and Major Rysel might have some comments on this as well, but we would ask for some clarity there, as some of our investigations that we would want under this act would involve could involve another agency, as Director Shannon testified last time. We do investigations for other state agencies and other entities, or could involve probation and parole, for example. So we do investigations that are not just limited to law enforcement purposes.
Major?
Yes, Mr. Chairman. We do a lot of different investigations. Specifically, we've done work for the FBI. We do stuff for, excuse me, local municipalities. We've done stuff for A&I, the Public Defender's Office, the Military Department, the Wyoming Department of Health, and the Wyoming Liquor Commission. So for law enforcement purposes, it's not just what we do. We also service other state agencies, and Director Shannon is very supportive of that if we have the time and resources to do so.
So is it your testimony, if we deleted those words compiled for law enforcement purposes on line 10, that otherwise working draft 49 would be acceptable to your needs?
Mr. Chairman, I would also say that line 11 and 12, where it endangers the life, health, safety, and welfare of any person, is not just what we do. We also have a lot of different security procedures that go into our investigations. So occasionally we do work that relates to what's called a serious incident review. So when we have a serious incident at one of the facilities, we do a complete review of procedures, both security, staff responses, how it affected the inmate population and such. So those would not be included in that definition if it was just for the purposes of the welfare of any person.
So are you recommending that we just put a period at the end of line 9, or add additional language after line 12?
Mr. Chairman, I don't know if it's appropriate or not, but for me, draft bill 48 is the most appropriate.
Questions for witnesses? All right, let's talk about draft 48. What makes it preferable to 49?
Mr. Chairman, draft bill 48 includes everything, the same thing that we do as peace officers. It includes the language that would be most appropriate and cover all of the work that we do for the Department of Corrections. Again, we do all kinds of narcotics investigations. We do canine operations. We do those serious incident reviews and such. Okay. It's a broad stroke.
Very good. Questions at this time for either witness? Very good. See how easy we are to get along with? You have to come back more often. Yeah. Anyone else wishing to talk about 48 or 49? Anybody on Zoom? Are we on Zoom? All right. Committee, your preference on 48 or 49? You have a motion by Senator Case, seconded by Senator Landon, to move LSO draft 48 for adoption. 49?
Other one, 49. I definitely prefer 49, Mr. Chairman.
Okay, so the motion is by Senator Case to propose LSO draft 49, and seconded by Senator Landon for 49, that this become a committee bill. Discussion. Senator Case.
Mr. Chairman, I'm really uncomfortable with the idea that this unit could do anything and it'd be immune to public records requests. So I like the idea of tailoring whatever it is to the extent of the request. It'll be a work in progress. We might have to tweak it over time. But honestly, it seems to me that Romanet 9 is pretty broad and would deal with situations where they assist other entities, as long as we're talking about serious stuff, life, health, safety, or welfare of any person. That includes internal drug investigations in my mind and all of that. So I would definitely support 49 as a way to get forward to have more discussion about this. And Mr. Chairman, I've been in the public records. We've had a lot of debate over time and the Public Records Act, and I just think it's a really important thing. And when you have people that can be immune from public records requests, dealing with people that are incarcerated without a reason for that, that's a really bad place to go.
Senator Landon, did you want to?
Well, Mr. Chairman, thank you. Senator Case outlined pretty much where I would come down as well. I'm not sure that we have the language completely right or where we might want it to be by the end of the process, but I kind of share the public records concern that the senator did. As much work as your Corporations Committee has done through the years to try to open for transparency in our government, I think this qualifies well, the fact that life, health, safety, welfare of any person, but I'd be comfortable pushing this bill forward.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I'll be a no vote. My preference is 48. It's cleaner. We have the approval of DOC. And second, the investigation that DOC is conducting, there's a lot of security reasons that they want to withhold that information. We heard during the last committee meeting about threats from certain groups such as gang members, and DOC has a responsibility to keep them safe via restricted housing, and so my preference is draft 48.
Thank you, Mr. Chairman. So I think that, it's obviously an interesting conversation, but 49 with where it's at, I believe does protect that. One of the issues that we have to have, and this is just something I'm going to kind of address here with my thought and heart on this, the checks and balance system, obviously with 3 branches of government. Another checks and balance is the people. To say, whoa, I see something maybe isn't quite right. And they can do that request. They're going, wait, something just doesn't line up here. And we're going to do a request that at the end of the day, us as the legislative branch, the judicial branch, the executive branch, all 3 branches have to be accountable to the people at all cost. And so what we want to do is we want to give you guys a mechanism to protect people, but not give you a mechanism that could protect a bad character or a bad actor sitting in a position of authority. And I'm not saying that's happening, but it will happen at some point in time because it's human nature. And so we want to give you the freedom to do your job, but we also don't want to give you an overbalance where someone could manipulate that for ill-gotten gain. So I believe 49 can do the job we need it to. It might require some help from you guys to make it where you feel that it could work into that confines, but I think 48 is really just like too much of a blanket that someone could manipulate and use to a disadvantage at some point forward. So I am for 49 and against 48.
Representative Craigle.
Thank you, Mr. Chairman. So reading the language of 49, I think it's actually more broad than 48. I think it gives more leeway to the department than 48. If you look at the second clause, it says, so the first clause, record of investigations conducted by, comma, or of intelligent information or security procedures of, which is more than just So that would allow them to withhold procedures, for example, like if I want to file a public records request regarding their procedures, I read that as allowing them to withhold that, whereas 48 does not. 48 only allows them to actually withhold an actual investigation that they've conducted or are conducting versus procedures and policies, et cetera. So I actually think to your point, I understand where you're coming from, but I actually think 48 gets you closer than 49. Thank you, Mr. Chairman.
Further discussion? Yeah, my only comment is, I think what the whole argument of the Department of Corrections has been is that the work of their investigation services unit is largely indistinguishable from the work of a police department in many respects. And we use the language in 48 and consider it adequate for police departments, state auditors, attorney general, city attorney, county attorney, sheriffs. But what I'm hearing among the committee is maybe it's not adequate for the special services unit. Representative Crago.
Thank you, Mr. Chairman. So our good lawyers over here just pointed out that I can't read. So they're the same. Thank you. That's
Okay,
accurate.
so no further discussion. I believe the motion, correct me if I'm wrong, Senator Case, is to move LSO Draft 49 as a committee bill, and is seconded by Senator Landon. So call the roll.
Senator Case? Aye. Senator Cooper? Aye. Senator Furphy? Aye. Senator Schuler? No. Representative Chestek? Aye. Representative Crago? Representative Haroldson? Aye. Representative Jennings? Representative Nemec?
No.
Representative Oakley? Representative Provenza, excused. Representative Rodriguez-Williams? No. Co-Chairman Landon?
Aye.
Chairman Washit?
No.
Cooper, I don't know.
Mr. Chairman, we have 6 ayes, 7 noes, 1 excused.
So motion, Representative Oakley? 48's moved, second by Nemec. So discussion on 48. Seeing none, we call the roll on 48 to move 48 as a committee bill.
Senator Case? Senator Cooper? Senator Furphy? Senator Schuler? Representative Chestek? No. Representative Crago? Representative Haroldson? No. Representative Jennings? Representative Nemec?
Aye.
Representative Oakley? Aye. Representative Provenza, excused. Representative Rodriguez-Williams? Co-Chairman Landon? Chairman Washit?
Aye.
Mr. Chairman, we have 9 ayes, 4 noes, 1 excused.
Very good. Thank you both. Now we have LSO Draft 60 on the Interstate Compact. I think you're needed to stay where you're at.
Yep. So, Mr. Chairman, this is working draft 0.5, 7-03 in the meeting materials. This is a bill draft the committee requested after hearing from the Department of Corrections on this compact. The language is based on language that the department provided to the committee at its first meeting. It is also extremely similar to the language that's used in the Western Interstate Corrections Compact, of which Wyoming is a part, and the legislature previously adopted into statute. This bill draft would adopt the Interstate Corrections Compact and have Wyoming join as a state party to that compact. And Mr. Chairman, I'm happy to go into as much detail as you wish. Since it is a compact, I may just hit more of the high points. So page 3 are the definitions for the compact. I would just note that institution includes any penal or correctional facility, also including a facility for the mentally ill as well. That's on page 4. Then page 4, beginning with line 12, this is an article of the compact concerning contracts. And the way the compact would work is that each party state may enter into a contract with any one or more of the other states that are party to the compact for the confinement of inmates on behalf of a sending state in a receiving state. The language on page 5 provides the requirements for those contracts that would be entered into under this compact. Page 6 concerns the procedures. Beginning with page 6 is the article concerning the procedures and rights that are associated with a contract under the compact. So describes the rights that inmates have under the compact who may be housed in another state, the rights of officials of the sending state to visit and inspect and the facilities that their inmates are held in. It requires reports on a periodic basis and provides for any hearings or releases that are associated with those inmates. Then moving on to page 10, this just provides language concerning the extradition of inmates who may escape while housed in a receiving state, as well as decisions of the sending state in relation to an inmate that's held in a receiving state. Then moving on to page 11, line 19, this article, Article 6 of the compact, concerns federal aid. A state party can accept federal aid for use in any connection with this, with a program that's affected by this compact. Page 12, the next article, Article 7, makes the compact effective when 2 or more states have enacted it into law, and then after it becomes effective if a state enacts the compact into law, which would be the case here for Wyoming. Article 8 is withdrawal and termination, and so it continues until a party state enacts a statute that repeals the compact, and then a state that is leaving the compact after repealing must provide written notice of withdrawal to all of the other party states. And that withdrawal cannot take effect under language of the compact, I'm on page 13 now, until 1 year after the notices provided have been sent. A staff comment just notes a potential consideration for whether that language requiring a year's notice would impermissibly bind a future legislature from taking some other action. Page 13, line 28, this is concerning other arrangements that may be made within or outside the compact. Article 10 on page 14 is a severability language, similar to what is in Wyoming statute already. And then beginning on page 15, Mr. Chairman, these are sections that were not included in the department's language, but are sections that were included when the state adopted the Western Interstate Corrections Compact. The language is virtually identical to those sections. It just requires the Department of Corrections to administer the compact. It allows the transfer of inmates to an institution in a receiving state. It requires the state and its agencies to enforce the compact. It authorizes the governor, I'm on page 16, to hold hearings as may be required under the compact. And then it gives authority for the governor to enter into contracts on behalf of the state for purposes of the compact. And then there's another construction and severability clause, and then 2 conforming amendments on page 18 to reference the compact. So in 713-420 on page 18, line 9, just inserts a statutory reference to the interstate compact. And then again on page 19, line 6 through 9, this is in the sex offender registration statutes, just includes a reference to this new interstate compact. The bill would be effective July 1, 2024. With that, Mr. Chairman, I stand for questions.
So, Mr. Fuller, on the construction severability provisions on page 17, with that language in the bill, if we were to find that the other language on withdrawal violated the binding of a future legislature. Would that severability clause then protect the rest of the compact?
Mr. Chairman, I believe that would be, that may well be the case. Not only this language, but the language that's in the actual compact itself provides for severability as well.
Mr. Co-Chairman.
Thank you, Mr. Chairman. So, Brian, thank you very much. As I read this compact language, nothing in this compels our state to do anything with another state, if I'm reading the language correctly, but it does, if we choose to enter into an agreement, it just outlines how we're going to do that. Is that correct?
Mr. Chairman, Chairman Landon, that's my reading of this. I think the key language is on page 4 that allows each party state, they may enter into contracts, and then if so, the compact govern how, how that would be executed. Yeah.
Thank you.
So comments from the Department of Corrections.
Thank you, Mr. Chairman. We don't have specific comments on this bill, but I would like to just clarify, Senator Landon, we use this compact to send inmates to other states largely as a result of the investigations that we talked about in the prior statute discussion. And so we enter into contractual agreements. We have to agree when we take inmates from another state, we agree, that sending state agrees, and the inmate agrees. And likewise, when we send inmates out of state, the other state has to agree, the inmate has to agree. So that is how that process works. We do have contractual agreements presently with 29 states. 23 of those states do ask us to put in this language into those contracts. And as you'll recall from Director Shannon's testimony, the reason we brought this as a topic is that it does, in essence, require us to enter into the compact language, which is really falls under your authority as the legislature versus our authority as the agency, but that's kind of operationally how it works.
So if I'm clear, we're already members of the Western Compact, but the reason for this interstate compact is to allow us to contract with states beyond those that participate in the Western Compact, but it's largely the same type of provisions, just that it includes a greater number of states. Is that correct?
Mr. Chairman, yes, that is correct. Most states have moved to the ICC from the Western Compact.
Representative Chestic.
Thank you, Mr. Chairman. And if you could clarify for me, so we're not leaving the Western Compact, we're staying in that and adding this as some additional states that we can contract with. And you started to say it and I'm not sure I got it. Why do we have to be part of the compact to make those contracts, or do we have to be part of the compact to contract with other states? What does this add that we don't already have?
Mr. Chairman, Representative Chestic, the authority in statute, and LSO would have to provide that statute, I'm not recalling, but the authority to enter into a compact rests with the legislature.
But if we, just to follow up on that, but if we're already able to enter into contracts without the compact with 29 different states, why again do we need to be parties to the compact?
Correct. If you choose not to move this bill forward, we would continue with that practice and we would contract with individual states, and we have been able to do that. We do, for the reasons I just said, feel that that is a bit problematic, but that is what we could continue to do.
Mr. Co-Chairman.
Mr. Chairman, thank you. So, Heather, I think what we're trying to drill down on is what does this compact do for you tomorrow when it passes that you can't do today? And as I read the compact, I guess it sets the bar in certain places, expectations, commitments that we make, but just generally speaking, what does this do for Wyoming that we can't do today?
Does it make a shorter contract?
Mr. Chairman and Mr. Co-Chairman, operationally, it doesn't do anything necessarily different. There are states that will not enter into agreement with Wyoming because we're not part of the ICC. So that could potentially pose a problem for us. We feel that entering into this compact provides us efficiencies and more states to contract with.
Okay, thank you.
Okay, anyone else wishing to testify on LSO Draft 60? Anybody on Zoom? Anybody else in the room? Closed public comment. Committee, what's your preference on 60?
I'll move it.
Moved by Senator Landon. Is there a second? Second by Nemec. Discussion. Senator Landon.
Well, Mr. Chairman, I'm not sure all of what this might do for us. We just had testimony that it may do something for us in the future. It is a bill that was brought to us by the Department of Corrections. So just in the interest of having a little bit of a debate on it, I moved the bill. It feels like maybe it's tipped in a favorable position for me to consider, but I'm not going to lose any sleep one way or the other. I mean, to be honest.
Further discussion. I keep seeing that coat rack and thinking it's a hand up over there. Senator Schuler.
Thank you, Mr. Chairman. And I guess I should have asked this question when you were testifying, but I wondered how many folks were actually sending out of state, and would they be going to these states that prefer that we be in the ICC?
Thank you, Mr. Chairman. Senator Schuler, we currently have 43 inmates housed out of state, 3 females and 40 males, and they are going to some of these states. Yes, ma'am.
Further discussion. Senator Cooper.
Thank you, Mr. Chairman. The thought that keeps coming to my mind is this really needed? I can see some advantages of it, but are we again out there finding a solution and in search of a problem? So I'm kind of leaning against tabling this thing.
Good. Yeah, my only thought was, there might be a small number of additional states that would only contract with us if we were ICC members. I don't see where it hurts anything since we're already bound by the language in the Western Compact and it's largely the same. So kind of with my co-chairman, not going to be a sleepless night one way or the other. So let's call the roll on 60.
Senator Case? Senator Cooper? Senator Furphy? Senator Schuler? Representative Chestick?
Aye.
Representative Crago?
No.
Representative Haroldson? No. Representative Jennings? Representative Nemec?
Aye.
Representative Oakley? Representative Provenza, excused. Representative Rodriguez-Williams?
No.
Co-Chairman Landon? Chairman Washit? Mr. Chairman, we have 6 ayes, 7 noes, 1 excused.
Mr. Chairman, that starts in the House. No, I'm kidding.
I thought we had 7 no, 6 ayes.
We did.
So, all right. Late in the day to be, trying to be humorous with your co-chairman over here. Thank you very much, Ms. Bev. Thank you for coming. All right, let's, do we have anyone here to testify on this next topic of guardians filing for divorce? Any witnesses in the audience? On Zoom?
This is Katie's bill.
Okay, so why don't we get an LSO walkthrough on this draft?
Chairman Washit, members of the committee, Katie Adams, LSO. This is 24 LSO 50, right of a guardian to seek a divorce on behalf of a ward, working draft .4. So the bill draft creates a new statute in Title III to specify the powers and duties of a guardian regarding divorce. Under subsection A, if a guardian determines a divorce is in the best interest of a ward, the guardian shall petition the court requesting authority to seek a divorce on behalf of the ward. Subsection B specifies what the petition must include. Subsection C specifies who must receive a copy of the petition. Subsection D requires the court to hold a hearing on the petition. It also requires notice of the hearing be provided to the parties and persons described in subsection C. Under subsection E, if the court determines the guardian established by clear and convincing evidence that seeking a divorce is in the best interest of the ward, the court shall grant the petition and authorize the guardian to seek a divorce. Subsection F specifies what the court must consider in making this determination. And then the staff comment explains that the bill draft is modeled after an Indiana statute, and the staff comment highlights some policy considerations for the committee. There's also some additional information that the committee has received about constitutional rights that may be implicated by this issue. And there's also an outline of some state statutes outlining sort of the requirements of this issue and petitions for divorce.
Thank you. Committee questions? Mr. Co-Chairman?
Thank you, Mr. Chairman. So, Katie, as I read this bill, I kept coming back to the notion of a guardian who would stand to benefit, and perhaps nefariously just decided that they didn't want the husband, maybe their stepdad, to get all the money. Can you point me in the right direction to give me comfort on that front?
I don't think it's there.
Do you see where I'm getting to, Katie? In other words, if my mother were married again and us siblings decided that we didn't want her to leave all of her money with her husband, we could utilize this law to get rid of the guy, right? That makes sense?
Chairman Washit, Co-Chairman Landon, I think there are protections built into it to, I think, help address some of those concerns. At least in this bill draft, you have the petition needing to be served on the ward spouse, the adult children who aren't already guardians. You'd also have a hearing to address the best interests. You'd have the ability for individuals to present evidence about that. You'd also have the court needing to assess sort of under the standard of review of best interests and determined by clear and convincing evidence. So, I mean, hopefully there are some protections built into it, but I certainly understand those policy considerations.
So I assume that the benchmark then, Katie, is the clear and convincing evidence that a judge would consider, and I'm looking at my legal friends here. I guess that's the only place that I'm having a little discomfort with the bill, unless I'm convinced that clear and convincing is a good enough bar.
Chairman Washit, Co-Chairman Landon, yeah, the standard would be that the district court would have to find by clear and convincing evidence that seeking a divorce is in the best interest of the ward. And then there are sort of considerations that the court needs to consider, including evidence about the desire or preference of the ward's spouse to remain married. It would need to consider any risk of harm to the ward's physical health, mental health, safety, or property, and it would need to give appropriate consideration to any evidence of the ward's intent, preferences, or decisions.
So my question, Katie, is I'm not all that familiar with guardianships and so forth, but does the ward still have the capacity to take any action independent of the guardian, or does the guardian like instead of position?
Chairman Washit, so guardianships are established when the ward isn't able to make those decisions, and so the guardian is making those decisions about the person of the ward, as opposed to a conservatorship where they would be making the decisions about the finances of that individual. So that individual wouldn't have the capacity to sort of oppose that.
So we could actually have the reverse situation where the ward wants a divorce, but the guardian does not. And then the guardian would act to prevent the ward from being able to move because the guardian has no standing to act. Wow. Further discussion, committee? Is there? Yeah. Well, this one's going to start in the Senate, so. All right, committee, is there a preference on this? Any public comment before we close? Didn't see any, and nobody on Zoom. So committee, what's your pleasure? The silence is deafening. Bill will be set aside. Bill draft set aside.
Committee members, be sure to let us know if you decide to take that as an individual bill. We'll be watching and rooting you on.
Senator Case will.
Okay, so it's 4:24. We're gonna, in consultation with the co-chair, we're gonna carry over item 9, mental health and vulnerable adult task force, till tomorrow. What time tomorrow? Co-chair, you find a time for that?
Yeah.
He's there?
Yeah. Chairman Larson is on Zoom right now, Mr. Chairman.
If he's there, we can take it up. I had texted the good representative thinking that we would not get through the agenda, so.
But it's
Mr. Chairman,
4:25 and he's here. Let's hear what
Want to take it? Let's get the
Representative Larson has.
good representative in here.
Mr. Chairman, can you hear me?
Good afternoon, Mr. Chairman, Representative. Good to see you.
Thank you, Mr. Chairman. And honestly, if it would serve the committee better, I am certainly open tomorrow if it helps you guys get through today's agenda sooner. So I leave that up. I'm flexible. I can do it now. I can do it tomorrow. Just what pleases you. I really am flexible.
I think we're waiting with bated breath, and
Okay.
Representative, I think we can get her finished up and get a good listen to the work you've been up to. Let's knock this out this evening. What do you think?
I think I'm ready to go, Mr. Chairman. Thank you. And thank you, members of the committee. The Vulnerable Adult and Mental Health Task Force, as you know, was set up by Management Council in an effort to continue the effort that's been ongoing for the past 8 to 10 years to develop and define the role of state for providing mental health services to the citizens of the state. This task force, as it's set up, has 3 senators, 3 representatives, the directors from the Department of Health, Department of Family Services, the Department of Corrections, and then a representative from the Department of Education, along with the Chief Justice, along with the court administrator, who might add is a pretty tough taskmaster. This task force was directed to make recommendations back to the legislature for consideration. Any proposed legislation coming from the task force has to be referred to a standing committee to have an individual sponsor. Hence, we have a couple of recommendations that I reached out to you, Mr. Chairman, and Chairman Washut, to see if you guys would maybe consider one of your next meeting in sponsoring. The scope of mental health issues are enormous. The task force elected to reflect on the work that's been done to date with the new state health facilities and behavioral health redesign, and focus on mental health issues that'll build on the work that's been done to date. The 4 areas that we worked on, and many of these involve this committee. The first one is the diversion of certain mentally ill people arrested for nonviolent misdemeanors away from the criminal justice system. We've got a pilot program that'll be starting up in Gillette to teach us what we don't know there. We're working on policy for adolescents with high behavioral needs. At any one time, we have around 15 to 20 young people ages 12 to 17 whose behaviors are acute enough that they need to be placed someplace, and we don't have until we can find long-term placement, we don't have a policy in place to take care of them, and our system doesn't accommodate them. So we find these adolescent kids, 12 to 18, some sitting in county jail, some sitting in emergency rooms, not getting their education and not, and certainly having not committed a crime. So we're trying to address that. We talked, as you know, about mental health services of K-12, and we're looking at that. But what I've come here to talk to you about today is a couple of legislative recommendations on our approach to vulnerable adults. The task force is working on policy to put into place in the adult protective services found in Title 35 to ensure our adult citizens have access to emergency services when the adult person, by reason of age-associated ailments or intellectual disabilities, are left without resources to protect them from exploitation or to provide them with safety and shelter until a more permanent solution can be found. In 2017, there was a governor's task force on vulnerable adults where several recommendations were made but were not moved forward. The task force thought rather than replow the field, they'd look at those recommendations again. And there are a few changes coming from that. And Mr. Chairman, I believe that you've been provided with a couple of bill drafts. And the first one that I'd like to share with you is 24 LSO 0023, which is DFS and law enforcement cross-reporting. And in 352103, the requirements, if you go to the statutes and look, there's a requirement for the Department of Family Services to report to law enforcement when there's been a vulnerable adult has been suspected of being or has been abused and neglected or exploited. But then in the next section, the law enforcement has a little different responsibility. And we heard both from law enforcement and the Department of Family Services that it seems logical that they would be the same. And so we would recommend in this bill that we amend 352103A D and conform that language to be the same requirement as the Department of Family Services. And so it would, in essence, it would change the language to read that if law enforcement receives a report that a vulnerable adult is suspected of being or has been abused, neglected, exploited, intimidated, or abandoned, or is committing self-neglect, law enforcement shall notify the department concerning the potential. And of course, the department is Department of Family Services. And this is important because sometimes law enforcement will get a report, the DFS just isn't aware of it, and then later find out that there really is a problem. And had they been notified by law enforcement, perhaps could have prevented any further problems. So, Mr. Chairman, that's the first bill we'd like for you to consider sponsoring. Would be happy to answer any questions on that bill.
Thank you. Committee, any questions? No questions? Anybody in the audience wishing to testify on this bill draft? Anybody on Zoom? Okay, committee, your preference on bill draft 23? Move the bill by Senator Cooper, second by Representative Craigo. Discussion. Amendments? Seeing none, call the roll.
Senator Case? Senator Cooper? Senator Furphy? Senator Schuler? Representative Chestek?
Aye.
Representative Craigo?
Aye.
Representative Haroldson? Representative Jennings? Representative Nemec?
Aye.
Representative Oakley? Representative Provenza excused. Representative Rodriguez-Williams? Co-Chairman Landon? Chairman Washit?
Aye.
Mr. Chairman, we have 12 ayes, 1 no, 1 excused.
Very. Senator Case.
I think it passed, Mr. Chairman. How long have these bill drafts been available to the public? Because they weren't in our other packet.
Mr. Fuller.
Yeah. Mr. Chairman, these were posted Friday.
Mr. Chairman, that's awful fast to do a bill draft and provide notice. We have another meeting. This is going to be a slam dunk easy thing. I would ask to recall the vote and to consider giving adequate notice to this bill and another bill at our next meeting. Friday doesn't count for notice.
Fair point. Committee? Is that a motion to recall?
Motion to reconsider only because of the notice issue.
We have a motion to reconsider. Do we have a second?
Mr. Chairman, I'd
Representative
be glad
Oakley.
to second. Or, you got a second?
Yeah, discussion?
Just for discussion.
Mr. Co-Chairman?
Mr. Chairman, I think that doesn't do any harm at all. I appreciate the good chairman suggesting that. I don't see any problem to hold this over. But I did not sense much concern on the part of the committee, so I didn't say anything. So if you want to back the vote off, that's fine.
And Mr. Chairman.
Mr. Senator Case.
I agree totally. I'm not trying to kill this bill. Motion to reconsider brings it up for a vote again. Ask that you vote no for passing it forward, but I'm going to try to slip in a motion ahead of that, which would be just to carry it forward to the next bill, next meeting, which would be tabling. And I don't know how LSO would rule on that procedure, but it would keep us from having voted against this.
Yeah, I think the committee's got the final voice on this. If the committee wants to carry this over till November, we certainly can.
Yeah, Mr. Chairman, I think after the vote to reconsider, I think anything would be,
Motion to table would be in order.
Mr. Chairman, for committee, I think that would be okay.
I think it'd be cleaner, Mr. Chairman.
All right, so let's call the roll on reconsideration.
Senator Case?
No. Yes.
That's fair enough. Let's be clear.
Yes, yes, yes.
A yes vote
For
says that we're
reconsideration.
going to reconsider this bill at the November meeting. That's the motion. Representative Craig, a question before we vote?
Yeah, this is just a bit of discussion. I guess it's procedural, and those of you who've been around a lot longer than me might know the answer. But is it just possible that if we don't do the motion to reconsider, or we vote one way or the other, vote not to reconsider, if we get a bunch of public comment in the meantime, can the chairman request that it be put back on the agenda for the next meeting without a vote of the committee today?
I think
Is that a possibility?
The thought is that if it's on the agenda, we're more likely to be fair to the public for them to offer opinion. If they think it's a done deal at this point, we may not hear much. So if we put it on the agenda in November, if people do have some comments, we can hear them in November. Okay, so a vote, an aye vote is to reconsider the bill in November. A no vote is that we live with the vote we just took. Call the roll.
Senator Case?
Aye.
Senator Cooper? Senator Furphy? Senator Schuler? Representative Testek? Representative Crago?
Aye.
Representative Haroldson? Representative Jennings? Representative Nemec?
Aye.
Representative Oakley? Representative Provenza excused. Representative Rodriguez Williams? Co-Chairman Landon? Chairman Washit?
Aye.
Mr. Chairman, we have 13 ayes, 1 excused.
Move to carry this bill over until our next meeting.
Yes, 23 will be on the agenda for our November meeting. All right. Mr. Chairman, take us to LSO draft 24 LSO 0021, working draft .5.
Thank you, Mr. Chairman. And before I go into 21, I just might share with the committee that when I made the request to the two chairmen, Chairman Washit contacted me, and my understanding was that we would bring this bill and do exactly what you've done, which was to consider it for consideration in one of the following meetings. So thank you. It was, it ended up where I thought we was going to go to begin with. So if I may, Mr. Chairman, 24 LSO 0021 is changing when the court orders an emergency service for a vulnerable adult. Those emergency protective services are good for 72 hours. This changes that. We heard from the agencies that sometimes, particularly in more rural communities, 72 hours doesn't allow enough time to get a more permanent solution in place. And therefore, the vulnerable adult sometimes finds themselves back in an unfortunate position, even though it can be extended for another 30 days. The recommendation was to have that initial order good for 14 days total, and that is really the sum of that change. And would be happy to answer any questions on that.
Questions? Senator or co-chairman?
It certainly makes sense to me, Mr. Chairman, but question, is there any fiscal impact at all?
No.
With this one? Okay.
Other questions? All right.
I have a question about the topic, Mr. Chairman.
Go ahead, please, Senator Case.
Representative Larson, thank you for being here today. The whole issue of mental health and vulnerable adults is related to a discussion we had earlier, and I don't know if you were online at the time, about the increasing number of people that do not have housing in the traditional sense and exist in our streets in Wyoming and largely living on those streets and suffering from substance abuse and other mental health issues. It strikes me that our statute that exists, the definition whereby someone is a danger to themselves or to others covers those people. They're clearly a danger to themselves. So is the task force thinking about the proposed legislation in terms of maybe addressing that population as vulnerable adults? And if not, why not?
Chairman Larson.
Thank you, Mr. Chairman. Senator Case, the conversation on vulnerable adult is what is the vulnerable adult, and we've had some definitions, considerations for that. But to your point, you're exactly right. And when we are having the conversation to define what the state's role in providing these type of services to the citizens of the state, we have to step back and say, are these people who have no housing and are in need of temporary housing, does that qualify as a vulnerable adult? And that is largely left up to the discretion of the agency. And then if it needs to go to the court could decide too. But under Adult Protective Services, I believe, if my recollection is accurate, that the Department of Family Services could make that decision to provide services to that population that you described.
Mr. Chairman, follow up?
Follow up, Senator Case.
Thank you very much for the answer, Representative. I'm sort of unhappy leaving it to the Department of Family Services to make a determination. I mean, I think we're getting close in this country and in Wyoming to actually making an affirmative decision that we want those vulnerable adults to be increasingly under court supervision. I think that's where we're coming. And I don't know if it's a matter of DFS deciding whether someone qualifies and they should take them in. It's more of a policy thing. Maybe we should be doing more, and this legislature should say, we need to do more.
Mr. Chairman.
Mr. Chairman.
Thank you, Mr. Chairman and Senator Case. And so I want to clarify that because I think it's important to understand that just because DFS intervenes does not require that it be that the court intervenes. And I think that's an important component. There has been some interesting conversation whether Adult Protective Services belongs in Department of Family Services or Department of Health or somewhere else. It's in the Department of Family Services because it's somewhat akin to the Child Protective Services, and that's why it's resided there for some time. But you've hit exactly the nail on the head on this whole conversation that will continue past this legislative session, in that we have to seriously have conversation and define the policy of how the state's going to respond to this evolution of our society that involves this population.
Chairman Larson, before I vote to extend this to 14 days, can you describe for me where typically are these people? Right? This order of emergency protective services goes out. Where are they placed? Who's looking after them? Are they in a hospital? Are they in a jail? Are they in a psychiatric ward? Where do these vulnerable adults go for this 14 days?
Well, thank you, Mr. Chairman. And that's a great question, and one of which encompassed much of the conversation. So I think your point in any of the examples that you listed there are valid, but not exclusive. They may not need to be in a jail. They may be only it may be something that your community mental health provider can provide temporary housing until their medication stabilized. This might be a rural resident of Farson or of Wamsetter, who neighbors all of a sudden see some anomalies in the way this individual, all of a sudden, Lloyd's really doing kind of some weird stuff. They're concerned. They call law enforcement. Law enforcement investigates and sees that Lloyd maybe is having some challenges associated with age. They call the Department of Family Services. Department of Family Services comes out and does an investigation and realizes that maybe there's some early signs of dementia and some other things. And reach out to family. There's no family available, no family known. So then what do we do with the person? And then that's when the court system would perhaps get involved and say, we need to provide some emergency services for this person. And because Lloyd doesn't necessarily want to go. And when they investigate, they find that his house no longer has heat, no longer has lights because he hasn't paid his bills. They find that through a little investigation that his resources are done. Perhaps has questionable capacity of making those kind of decisions. And so maybe this temporary 14-day exercise is to help make sure that they're safe and in shelter until a more permanent resolution, until they can start a guardianship position, do further research and determine if maybe they've missed family someplace, but mainly just trying to protect the person from perhaps making some wrong decisions based on capacity that has developed that is causing them to make unwise decisions. And so when you do that in Farson, maybe it takes a little while to get all of that done.
So as a follow-up, thank you for that answer. This individual who's being offered emergency protective services may not be excited about the services being offered, and they may see it as an adverse circumstance at that point. And it might well be in some respects. And so that's why I'm getting a little nervous about extending this from 72 hours all the way to 14 days, because if we're taking an individual and we're placing him someplace against his will for 14 days, does he have any recourse during that 14-day period, or is he just stuck for 14 days?
Thank you, Mr. Chairman. And you are just walking down some of the same paths we did during this discussion, because the difference between this vulnerable adult and a child is this guy is an adult and has rights, right? And he gets to, so if Lloyd's living there in Wamsetter and wants to be a hoarder, he has, and is not hurting anybody else, he has the right to do that. But if there's some question on his ability, similar to somebody that perhaps is being titled under Title 25 at risk of hurting themselves or others. We know that sometimes it takes more than 14 days to get that evaluation done to determine if indeed that is warranted. There is, and it's a delicate balance, Mr. Chairman, that we make sure that we're not imposing upon their rights as an adult and as a citizen of the state to live the way they want. But at the same time, when they do, sometimes those emergency services need to be in place a little longer than 72 hours.
Very good. I'll probably be an aye vote today, but I may have an amendment for this before we get too far down the road. Other questions for Chairman? Senator Case.
Just to tell you a little story, this self-abuse and neglect that's in the law, that's something I did a long time ago. That was my bill. And it had to do with a very confused woman trying to live in her home, and she appeared in the middle of winter just wearing a bathrobe and slippers down at a restaurant. She'd walk blocks, and someone asked me if there's anything we could possibly do to help her. And this is what came about. The Department of Family Services worked hard to have this self-abuse and neglect. But I'm asking now, the standard we talk about, we're thinking about someone that lives in our communities, they have housing, but they're having real challenges. But the homeless people, or whatever you want to call them, they fit this criteria, and they need this assistance worse than anyone. But because of the substance abuse piece correlated in some of these, it's very difficult. But I don't know if 14 days is the answer, but I think we need to expand this in a different direction and use this power of the court to address our homeless situation. And homeless is just, they're using unhoused now. I don't know what word to use. It goes from vagrants to drunks to veterans. So I don't know. This is a very big deal, and I think we ought to think of the implications of it in the big picture too.
Mr. Chairman.
Chairman Larson.
Thank you. And I think there's a distinction in populations related to what this bill is doing, and it actually is adding to this behavioral health redesign that we've done a couple of years ago, which I think really takes the initial steps to address the issue that Senator Case is talking about. So you'll recall a couple of years ago, we prioritized those populations that the state would fund to help with who are mentally ill, and that would receive services. The ones that Senator Case is talking about, substance abuse, mental health, medications, shelter, those sorts of things, that they would be a priority population to receive those through the community mental health centers. And those people, those indigent and seriously mentally ill living without homes, are in that priority population. And we've worked the last 2 years to put all of the rules into place, and that starts taking effect in June of this next year, and hopefully really relieves some of that pressure on that population that Senator Case has identified. So I think we've tried to address that population in the first go round. Our community mental health centers are positioned and are getting positioned to really implement that in more detail.
Okay. No further questions. Do I have a motion to discuss this meeting again at our November meeting? Is there such a motion? Moved by Chestick, second by Oakley. Call the roll. All in favor, say aye.
Aye.
Those opposed, no.
Chairman,
Mr. Co-Chairman.
I just want you to know I'm still feeling pretty bad about Lloyd. You know,
Lloyd needs help. There's no doubt about that.
Thank you, Mr. Chairman, for all the
Thank
work
you,
of your
Mr. Chairman.
task force. We look forward to further discussion in November to see where we take these bills.
Thank you, Mr. Chairman. Thank you, committee.
Mr. Fuller, you want to bring us home? Tell us where we're at?
Well, Mr. Chairman, I think we're at the end of the agenda for today. Mr. Chairman, if you'd like, I'd be happy to run through the committee's actions for the day.
Please, the committee directors.
Yep. So, Mr. Chairman, the committee voted to continue 24 LSO 62, the influencing judges offense, with amendments. The committee voted to continue 24 LSO 61, the rural attorney program. And then the committee would move forward to the next meeting, 24 LSO 23, DFS and cross-reporting, and 24 LSO 21, emergency protective services effective period. The committee voted to sponsor 24 LSO 48, public records DOC investigations. And then the committee took no action on the following 5 bills: 24 LSO 57, statewide medical examiner; 24 LSO 63, the influencing offense amendments bill draft; and 24 LSO 64, personal publication of judges prohibited; 24 LSO 65, sheriffs and court security; and 24 LSO 50, guardians and filing for divorce. The committee failed to sponsor in a roll call vote the following 2 drafts: 24 LSO 49, which concerned DOC records, and 24 LSO 60, Interstate Corrections Compact. And then, Mr. Chairman, there was a request for research on what other states have done in terms of laws related to homelessness issues. And so we will we'll conduct that research for the next meeting.
Very good, thank you. Mr. Co-Chairman, any directions for this evening? Dress code, arrival time, map, or directions?
well, Mr. Chairman, I hope you can join Robin and me for beverages, a little bit of food to the committee. And I think you have the address in an email, hopefully, that I sent to you, but you can also plug that into your Google Maps or whatever, and hope you can come by. Should be a nice chance to loosen up our ties just a little bit. So, thanks.
We will 6 p.m. What I had.
We want to start early tomorrow, or are we okay? Mr. Chairman, you don't have to worry about that. I think you just get over there, there'll be a cold beverage or whatever, so.
All right.
So committee, just real quickly regarding tomorrow, we'll go ahead and start at 8:30. Let's be ready to spur the horse again. We've got a lot to consider and some pretty heavy items, especially in the morning. We may have quite a bit of public comment, I would suspect, and obviously on that second day, we like to get people out and on the road. So let's be ready to get after it in the morning. Good job, Mr. Chairman.
We stand adjourned until tomorrow morning at 8:30.